Coming up next, live coverage of a Senate Foreign Relations Subcommittee investigation of the Bank of Credit and Commerce International, known as BCCI. The Subcommittee on Terrorism, Narcotics, and International Operations has held 4 previous hearings on allegations of bank fraud and money laundering at BCCI. Today's hearing is the first of 5 scheduled to take place over the next week. The witness at today's hearing is James Doherty, an attorney from Miami, Florida, who has been investigating BCCI on behalf of the insurance company Lloyd's of London.
Subcommittee on Terrorism, Narcotics, and International Operations of the Foreign Relations Committee will come to order. Today we begin the 5th day of hearings in this subcommittee on BCCI Bank and the BCCI scandal. We're looking at the implications of this bank's dealings on U.S. foreign policy. We're looking at its implications with respect to the war on drugs, and also the role of foreigners in our domestic financial system. This is the beginning today of a series of hearings over the course of the next week. Next week, we will be hearing from a longtime insider in BCCI, one of the major financial officers of the bank, who will be, for the first time, telling publicly his knowledge of exactly what happened with respect to the many involvements of the bank here in this country. In addition, we will hear from Mr. Bert Lance with respect to the National Bank of Georgia and early introductions of Mr. Abadi and BCCI in this country. And then on Thursday, we will have Messrs. Clark Clifford and Altman appear before the committee in order to answer questions with respect to this matter. And finally, on Friday, time permitting, if we don't spill over and need a second day with Mr. Altman and Mr. Clifford, we will have the CIA before the committee to talk about CIA involvement and knowledge with respect to this bank, and possibly a State Department. Today we are going to look at a case study, if you will, on a particular branch's direct involvement in criminal activity. A lot of people have heard over the course of the last months about BCCI's cultural criminal activity, or the culture of criminal activity as it's been referred to. There have been many oblique references to arms dealings, to smuggling, and to other activities. But no one has really described what that was or how it happened. Today we're going to do just that. Today we're going to really open the window on a particular case of smuggling and arms dealing and learn something about how BCCI contributed to that. Now, I might add, in this morning's Washington Post, there is an article based on yesterday's Foreign Relations Committee hearing regarding banks and international agencies' involvement in the nuclear program in Iraq. We're going to hear something today about BCCI and nuclear programs. But what this article that appears in the Post and what yesterday's hearing describe is how financial institutions contributed to Iraq's building of a nuclear program. This particular article and yesterday's hearing are really the tip of the iceberg. And what today is going to help us understand is precisely how financial institutions are contributing knowingly and willfully to a broad spectrum of criminal enterprise. We know that already as to money laundering. We know that there is really almost an hypocrisy with which the International Banking Committee asserts the Basel Convention premise, know your customer. Know your customer is supposed to be the means by which people make judgments about who they're dealing with. People know their customers pretty well when it comes to credit and giving out money. But when it comes to taking in money, these banks seem to be ready and willing to not know their customer so well, or to not want to know their customer so well. And today is really a case study in the way in which a bank, a supposed upstanding and important member of any community, can be, if it wants to be, an integral part of the enforcement of our values and our laws. But how, if it chooses not to do those things, it can be an important part of the conspiracy that rips at the fabric of those values and those laws. And BCCI is just a case study in exactly how that can happen. We know from prior pleadings as well as prior cases that there are banks of good repute that regrettably have fallen prey to the easy money that flows in criminal enterprise and that have paid a price for it, many of them. But regrettably, what this article suggests, and what today's hearing will not just suggest, but which will show, is that by fancy dealings on bills of lading, by playing games with letters of credit, by dealing with nefarious types that these banks have reason to know, or in fact do know, are involved in illicit activities, those banks become partners in criminal activity. Now today we're going to have testimony about a specific case involving a Jordanian arms dealer by the name of Munther Bilbazi, who, as you will learn, it will be alleged, used BCCI to carry out covert weapons deals, the bribery of foreign officials, commodities fraud, and tax evasion in the United States and elsewhere. The case raises, regrettably, further questions about the handling of these matters by United States law enforcement agencies. Mr. Bilbazi's banker was a man named Amjan Awan, who was deposed by this committee in 1988 and who was Manuel Noriega's personal banker at BCCI. In previous hearings, witnesses testified before this subcommittee about how various U.S. officials and agencies fought to keep Noriega's drug dealing secret and to prevent his exposure because of concerns that it would embarrass our government. The fact that Amjad Awan and BCCI were simultaneously personal bankers to both Noriega and Bilbazi may also be a coincidence. But it is also possible, and it raises the question, that U.S. government agencies may not have been able to address the issues raised by the information that they did have on Bilbazi and BCCI because of the Noriega connection. Before we begin, I just want to caution the witnesses, as I have prior to their coming here, that we want facts, not surmise, and that we are going to document, with the admission of a significant volume of documents, the assertions that are being put forward here today. One final comment I just want to make for the benefit of the committee, and I want members of the media to be aware of, is that this committee has on occasion been criticized supposedly for chasing goblins or for looking at strange and nefarious types that people didn't take seriously. And I can remember back in 1986 when we issued our first report in which we pointed the finger at the private aid network to the Contras and talked about the drug running and gun smuggling, that many people were very quick to dismiss our witnesses because they were felons and because they were drug runners. I am quick to point out today that those very people are the principal witnesses that our own government is paying significant sums to and using as their witnesses in a number of major drug cases in this country, not the least of which is the prosecution of General Noriega. And I finally would point out that a number of those people that we had then asked questions of and were pursuing are the very people who have pled guilty in recent days because they lied to this committee as our inquiry was ongoing. And I'm referring obviously to Mr. Alan Fears, to Claire George, and to Elliot Abrams, for whom specific counts of their indictments are lying to this committee. And I say that not with any pleasure or glee, but because I think it's important that this committee's record of correctness be set out and be understood. Before we turn to the witnesses, I might also point out that Lloyd's of London and the gentlemen in front of us who were engaged by Lloyd's of London to pursue insurance fraud, which is what led them to their understanding of the BCCI involvement, expended some $6 million and major staff personnel in order to pursue one element of one branch's involvement in BCCI. This committee was criticized for expending some $200,000 with only 2 personnel over a 3-year period to pursue the entire BCCI investigation. Senator Brown.
Thank you, Mr. Chairman. I think it's appropriate to note here that you have played the leading role in bringing this issue to the forefront, and I personally am very appreciative of the leadership you provided in that area. The simple fact is that we've long recognized that matters of war and peace have an international flavor to them. Since World War II, the world has begun to recognize in a very broad way that we live in an international market versus a local market or a national market, and that has dramatically impacted our statutes, both in business regulation, as well as trade matters. Taxes have clearly been impacted by an adjustment to an international and a world market. Health matters and a variety of other things. We have slowly begun to recognize in the last 4 decades what an international village it is that we live in, and tried to adjust our laws to accommodate that. One area, though, that we are woefully behind the times is in recognizing that crime has gone international. And I don't mean that it hasn't been discussed or thought about, but the simple fact is we have never recognized it from a legislative point of view the way it's necessary to approach it. The current cases involve an excellent example. The simple fact is that while criminal activities are illegal in each country, that there is a woeful lack of mechanism of recognizing how crime can operate on an international basis and thus circumvent national laws. I think what we have is an excellent example, or a tragic example perhaps I should say, of how these loopholes allowed an international criminal conspiracy to be fostered and developed. It's quite clear that this nation has not developed the kind of statutes we need to do to deal with this international criminal problem. This is an example where banking practices become an integral part of a criminal conspiracy. And while we have been enthusiastic as a nation about regulating banks, perhaps even too much in some areas, this is an area that simply has been neglected. And Mr. Chairman, I believe that the important hearings that you've brought forward will lead to significant new legislation that will attempt to deal with international criminal conspiracies and will reach out in a wide variety of areas that will impact U.S. statutes, specifically with regard to banks. But I suspect, in addition, we'll have to be looking at international mechanisms to make sure that the U.S. laws can be enforced. And I suspect our trading partners will have similar concerns. So I see the hearings today as having a major impact not only in exposing criminal practices, but a major impact in developing new legislation that can deal with these practices.
Senator Brown, thank you very much. And let me just say for myself, I appreciate enormously your bipartisan and deep commitment to getting at this and your help in doing so. I think we are indeed going to be able to produce some legislation out of this. And I think there are a number of areas where we began a few years ago in trying to get currency transaction reports from offshore banks because of the huge loophole that exists today. Many Americans don't realize it, but American banks are required to keep transaction reports on any cash transaction of $10,000 or over. But the minute that American bank opens a branch offshore, it no longer is required to provide those reports, nor is any foreign bank offshore required to do so. So we've created an incentive to move cash transactions in and through these offshore accounts. And in an age where we are literally transferring on a daily basis trillions of dollars through the international banking system by electronic wire, people have huge menu in front of them for ways to avoid accountability. The system is way behind, as you've said, way behind in creating accountability in that, and really has become an aid, a boon, if you will, to criminal activity. I think it is absolutely vital that the G7 at least, and perhaps G15, stop talking about this as they have been and really start to try to do something about it with international agreements on how to monitor this kind of activity. Senator Simon.
Thank you. Unfortunately, I'm going to have to just be here briefly, but I have read your statement, and I shouldn't be reading in advance, but when you say it is our conclusion that what worked well with coffee might just as well have worked with cocaine or other illegal drugs. And the second thing, the failure of the Justice Department to respond, and this is not just something that happens with this administration or Republican administrations. It's a bipartisan thing that happens too often. I think there has to be some mechanism created, when talking about laws, where people, maybe it's an ombudsman in the executive branch, where people whether it's your department or HHS or anyone else, where an agency fails to respond to something that is essential, that there be someplace else you can turn. And maybe it is simply that people have to turn to us. I'm not sure. But clearly, we have to just not look at what has happened. We have to say, how can we improve the process? And let me just add my appreciation of your work and your leadership, Mr. Chairman, and let me add, if I may get Senator Brown's attention here for 1 minute, let me just add my appreciation also for Senator Brown, and he is, not only is he working in a bipartisan way here, he's been a real legislator. I serve on another committee with him. And I appreciate your willingness to dig in on these things and do a job that needs to be done for this country.
I've merely been trained by the senator from Illinois.
You are kind. Thank you, Mr. Chairman. I apologize in another 15 minutes.
We welcome you here today and appreciate very much your coming. I'd like to ask both of you if you would stand to be sworn. And do you swear, do you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. If you would each state your name for the record and then identify yourselves and proceed with your opening statement. James Doherty. Would you pull the microphones close to you, please? And I think speak right in. These are not the best microphones. And bring it a little bit closer there, if you would, Mr. Lerman. Thank you.
James Doherty, 1301 Dade Boulevard, Miami Beach, Florida.
Pull it down a little bit and even a little closer. Okay.
Thank you. And my associate, Richard Lehrman, is here with me. He practices law with me at our same office at 1301 Dade Boulevard, Miami Beach, and my investigator, Vincent Valls from Miami, Florida, who has worked on this claim in our travels to Central America.
Would you proceed with your opening statement?
Thank you very much, Senator Kerry, Senator Simon, and Senator Brown. My associate Richard Learman and I are attorneys admitted to practice in the state of Florida. We are engaged primarily in the defense of commercial insurance litigation. We are here at the request specifically and pursuant to subpoena of your subcommittee to discuss what we have learned about the Bank of Credit and Commerce International and subsidiaries in the course of protracted litigation that commenced in the federal courts in Miami, Florida, the Southern District of Florida, beginning in January of 1988, involving one of its best high net worth customers, Munther Ismail Bilbazi, a Jordanian citizen who resided both in Hollywood and Boca Raton, Florida. What our experience in 3 different lawsuits has provided us, and we wish to share with you today, is a window through which you can see how Bank of Credit and Commerce International supported this criminal client in various violations of the United States Code that began early in 1982. Looking at the case of Munther Bilbazi, who was both a smuggler of commodities and a clandestine arms dealer, you will be able to see how important the bank was as the financial partner in facilitating his criminal activity in violations of the United States Code and the laws of Central America. Mr. Bilbazi violated the laws of the Central American countries, at least of Honduras, El Salvador, and Guatemala, as well as the United States. He has recently been indicted in the Southern District of Florida, and a copy of the entire criminal complaint and the indictment will be provided and made a part of the record. That indictment relates to coffee smuggling and preparation and filing of false income tax returns. His accountant was also indicted. Mr. Bilbazi, you should know, is now presently residing in Amman, Jordan, has announced to the world press he does not intend to return to the United States. There is an issue as to whether or not he can be extradited. His co-defendant, Mr. Grushoff, was active in the preparation of his tax returns and the books and records, which were a direct impediment to the unraveling of this task, as well as from the books and records of BCCI. Now, Bank of Credit and Commerce International, SA, and its affiliates had 2 branches, one in Miami on Brickell Avenue and one in Boca Raton, Florida. Mr. Bilbazi was a direct reason why the Boca Raton branch was opened to facilitate his commercial activity with that bank. Indeed, one of his relatives, Fakhri Bilbazi, has been and is today, although the bank is in receivership, as we all know, the senior bank partner in BCCI Amman, Jordan. Mr. Bilbazi, from the evidence that we have reviewed, has moved various funds of his 3 corporations, Coffee Inc., Orion Systems Inc., and Mura International, with the direct connivance and participation of BCCI, to conceal accounts, arrange cash payments, and facilitate the smuggling of coffee and other commodities through Central America into the United States. When our investigation began, and there should be a brief word about this, we knew nothing of Munther Bilbazi or BCCI. Very simply, Senator Simon, Munther Bilbazi individually obtained what is called a fine arts policy of insurance to insure what he represented to a particular underwriter, Richard Fielder, were a collection of antique rugs and a Chinese vase. The appraisals were later determined to be absolutely fraudulent. He also obtained, in the name of his company, Coffee Inc. or Orion Systems Inc., an insurance vehicle called a marine insurance shipment to facilitate the movement of coffee. 2 claims were filed in short succession, Senator Brown, after October 24, 1986. That date is significant because that was the date that the world price of coffee had dropped over 200 points. Within 2 days of that significant economic event, Mr. Bilbazi filed a false insurance claim, claiming that his home had been burglarized. In the course of the investigation of that claim, Mr. Bilbazi stated under oath that his company, Coffee Inc., had sustained a financial claim and loss of some $4 million as a result of the switch of some 12,000 bags of coffee. And it was at that point, in order to demonstrate the existence and validity of the claim, that Mr. Bilbazi began to introduce vast, incomplete sets of records of Bank and Commerce International. Now let me take a further minute to explain our involvement in this matter. Lloyd's rejected, the underwriters at Lloyd's, both claims on the grounds, briefly, of fraud and false swearing. The documentation supplied by Mr. Bilbazi, particularly in the Coffee Inc. claim, demonstrated on its face that there were no bills of sale, there were no contracts of sale. All that was given were a series of cashier's checks. I wish to stress that even though we were involved with litigation against BCCI as a non-party witness and Mr. Bilbese as a defendant, we are not here to try our case, but rather to convey information we have learned concerning the operation of Bank of Credit and Commerce and, the United States government's response to what we obtained through subpoenas from grand juries. We do not purport to have knowledge of all of BCCI's operations in its network of 69 countries. We will limit our remarks to those transactions which involve Mr. Bilbese in criminal conspiracy with the bank's operations in Miami, in England, and in Amman, Jordan. The documents produced in the litigation since 1988 that we have obtained from the bank at different times, from Mr. Bilbese and his corporations at different times, and from third-party witnesses exceed the size of a large warehouse. We have attached to the various records what we have a fragmentary selection of some of those records in order to demonstrate the issues of coffee smuggling and arms violations here today. On the first topic of arms dealing, you might ask, what is the relevance of an arms dealer to contracts of insurance? Senators, that goes to the moral hazard of the applicant himself and the obligation in utmost good faith that an applicant for insurance disclose his true activities. Mr. Bilbese did not do that. We have documentation that there are at least 7 separate transactions of major arms shipments in which Mr. Bilbese was involved with weapons either obtained or supplied from the United States or England, which ultimately went to Jordan. The first involved a sale of small arms to Honduras and El Salvador. During the brief 1969 soccer war between Honduras and El Salvador, Mr. Bilbese sold small arms or light armaments to both El Salvador and attempted and did sell some of the armaments to Honduras. The second transaction that we are aware of began in 1974. This clandestine shipment of British-made Centurion tanks, surface-to-air missiles, and jet aircraft that were given by and sold by the government of England to Jordan resulted in a clandestine subsequent sale when those weapons became obsolete by Mr. Bilbese, and they were brokered to South Africa. We now know that in 1974, a particular reporter, Martin Walker for The Guardian, was in Jordan and came upon this particular transaction, which historically in the world events was a shattering revelation because world opinion had prohibited the sale of weapons to South Africa. Mr. Walker in Jordan came across this event, publicized it. It led to an official cessation of some of the shipments and a recognition by Jordan that those shipments had occurred. In 1975, we now know that Mr. Bilbese had also participated in the sale of surplus F-86 North American Sabre jets from Yugoslavia to Honduras. This becomes significant since in 1978, Mr. Bilbese once again became involved in a sale of the retrofitting of the entire corps of British and American-made tanks, which the Jordanian government decided to update to be on a position of equivalency with the State of Israel. That contract resulted in a claim by Mr. Bilbese and his corporation, and still one other shell corporation, to seek in the American courts and federal court in Michigan commissions over $7 million. All of these facts were not revealed to the underwriters at Lloyd's. We know that during the years when insurance coverage existed, beginning in 1983 and before the filing of the false insurance claims in 1986, that Mr. Bilbese had a former operative of the Central Intelligence Agency, Mr. William Toten, working in his company, supposedly, and which we do not believe, for the sale of coffee. We know that in 1984, upon the retirement of General James Vaught, a three-star Army general from the United States Army, that there were attempts also by Mr. Bill Basie to sell weapons. These proceeded ultimately in 1985 by further attempts by Mr. Bill Basie to sell weapons to the Contras through Adolfo Calero. In 1987, in the midst of the litigation and the investigation that had resulted from the present claim, Mr. Bill Basie attempted to sell 10 Northrop F-jet fighters, F-5s, and 18 Sikorsky S-76 helicopter gunships from Jordan to Guatemala with some 13,000 general-purpose bombs. Mr. Bill Basie attempted to finance this sale of American-manufactured arms without the requisite United States State Department and user certificates through originally a $34 million letter of credit. This letter of credit was initially issued but was not completed by BCCI in Amman, Jordan. Despite the efforts of several intermediaries on Mr. Bill Basie's behalf, including a former consul general in Miami and several Guatemalan generals, all of whom, as of last week, are now under indictment by the Republic of Guatemala, the financing for the complete transaction fell through. Mr. Bill Basie set up a $5,175,000 letter of credit, naming BCCI Miami as the advising bank for 3 of the, quote, end of quote, civilian helicopters, which were manufactured by Sikorsky S-76 helicopters in the possession of King Hussein of Jordan. Mr. Bill Basie admitted that these obsolete Jordanian helicopters were obtained for approximately $2 million and were later sold to the Republic of Guatemala for some $5 million. Discovery has revealed various facsimiles from Mr. Bill Basie and his intermediaries in Guatemala, containing a list of various Guatemalan public and military officials, including the brother of the former president of Guatemala, Vinicio Cereza, Milton Cereza, to whom various kickbacks of profits from this completed transaction were directed. The Bank of Credit and Commerce International wire transferred these funds to Bank Lumi in Miami Beach. Included in the payoff list was a mention of some $400,000 to BCCI, and in parenthesis MB, which we contend, and we believe we have evidence, represented a kickback to BCCI Miami. These assumptions are corroborated by the issuance of BCCI cashier's checks to all of the persons named in the payoff list in the same amounts listed on the payoff list. In addition, BCCI Miami received the $400,000 assignment of proceeds from the letter of credit when the $5.1 million sale of the helicopters was completed. In pleadings which Lloyd's has filed seeking sanctions in the Southern District of Florida, we have argued that this illicit sale of United States manufactured arms from Jordan to Guatemala, which Mr. Bill Basie brokered, was directly tied to our litigation. The payoffs to these Guatemalan officials were made soon after the disputed insurance claims involving coffee smuggled into the United States, and which Mr. Bill Basie contended was mysteriously switched, for which he sought insurance coverage. Our investigation of this insurance claim for a coffee loss centered in Guatemala, since the coffee, although claimed to be of the origin of El Salvador, in fact was grown in Guatemala, was purchased from Guatemalan brokers, stored in Guatemalan warehouses, and trucked from Guatemala to Port St. Thomas de Castilla. When the coffee arrived in the United States, the marks on all of the bags were changed. The greatest resistance that we received was when we began the process of investigating whether or not there was an insurance claim that was valid when we attempted to verify the origin of the coffee in Guatemala. We determined that the bags were falsely marked, that the coffee in the subject claim, as all previous shipments, was smuggled. And it was at that period of time that Mr. Bill Basie and the bank had attempted to block this investigation by initiating and then completing a partial arms shipment. It is a documented fact in the Southern District of Florida that subsequent to the unraveling of this tale of smuggling, of political payoffs, that there were attempts by Mr. Bill Basie's Guatemalan attorneys to bribe our attorneys in Guatemala City, which led to, with the consent of our Guatemalan attorney who was investigating and assisting us, a tape recording made by agents of the United States Department of Justice, the Drug Enforcement Agency. Those tapes were filed of record. The fallout from the completed sale of these three overpriced and obsolete civilian helicopters involving kickbacks to Guatemalan generals and other officials has now resulted in widely reported national scandal in the Republic of Guatemala and, the indictment not only of the former president of Guatemala, Vinicio Cereza, and his brothers, but other members of the military. I'd like to turn for a minute now to an explanation of the coffee smuggling scheme. As we all know, coffee is one of the most significant, important commodities in world trade. Because of the existence of the International Coffee Agreement, Senator Brown, in 1982 through its termination in February of 1986, there were two international prices for coffee. Agreement coffee sells for much more than non-agreement coffee. What Mr. Bill Basie and his alter ego companies, Coffee Inc. and Orion Systems Inc., during the years 1982 through 86, was buy coffee in Central America as non-agreement coffee and then sell it in the United States as more expensive agreement coffee. He entered into a complicated system of a vertical conspiracy in which he bribed members of shipping lines, agents at the ports in Central America, and as Mr. Lehrman will describe, used three different methods of illegally introducing coffee in multiple successive violations of United States law. When the coffee arrived in the United States, it was remarked. There were kickbacks made to people in the United States to rebag the coffee and then to transmit it to various coffee buyers in the United States. During the years 1983 through 1987, Mr. Bill Basie directed BCCI to issue in excess of $100 million in letters of credit to finance the purchase of coffee from various Central American countries, which included El Salvador, Guatemala, Honduras, and significantly, coffee in Panama. Mr. Bill Basie ensured the inland transit. The second aspect, warehouse storage, and then finally the open marine ocean shipments of this coffee from various Lloyd's syndicates which we represent. Under the insurance contract, this Central American coffee was purportedly destined for third world countries such as Aqaba, Jordan, or Syria. In reality, each of those shipments, Senator Brown, was smuggled into the United States for resale to roasters or brokers in New York City, Miami, or New Orleans. My associate, Mr. Lehrman, will describe the methods by which the coffee was smuggled into the United States, including the ports of New Orleans, Louisiana, Miami, and Tampa, Florida. Although many records have been deliberately destroyed, we have been able to reconstruct the illegal importation of coffee into the United States, for which Mr. Bill Basie paid, with the cooperation of BCCI as his financial partner, in excess of $34 million. In addition, we have been able to trace kickbacks of some of the illicit profits from the resale of this coffee to the United States shippers, storage facilities, brokers, the roasters, and of course, to various BCCI officers who participated in this continuous scheme. The insurance claim, as I earlier indicated, which was initiated in February of 1987 for an alleged coffee switch during the spring of 1986, all emanated when the world price of coffee fell in October of 1986. Smuggling, therefore, became no longer profitable to Mr. Bill Basie, and he attempted to recoup his profit by claiming that cheap, low-grade coffee had been switched in each of some 12,000 bags, and therefore he was entitled to make this marine claim, so that in reality the false insurance claim was an attempt by him to recoup the paper loss that he sustained as the world price of coffee fell between April of '86 and October of 1987. The United States Attorney's Office for the Southern District of Florida did file an indictment against Mr. Bill Basie on August 5th, 1991, A criminal complaint was filed by his office, the Office of the United States District Attorney, on May 5th, 1991, barely 1 day before the expiration of the statute of limitations. Mr. Lehrman will describe more fully a review of BCCI records, which were not withheld in discovery or destroyed, that reveals that the coffee smuggling conspiracy at all times took place with the full cooperation and knowledge and direct bribery and payment by various officers of BCCI in Miami and Boca Raton. Moreover, although efforts have been made to characterize this conspiracy as a local operation involving 2 Florida BCCI officers, documents do demonstrate that the scheme was financed in part by bank guarantees from BCCI Amman, Jordan, and approved by BCCI's Central Credit Office in London, England. And we now know, as a result of discovery that we have uncovered in the last 6 months, Senator Kerry, that the same personal banker used by Munther Bilbezi was, as you've indicated in your opening remarks, the same personal banker of General Noriega, Amjad Alwan. We additionally know that substantial payments, Senator Brown, were made by Munther Bilbezi to Gerardo Harris, the ex-treasurer of Panama, who was the direct financial link between Munther Bilbezi and BCCI and General Noriega. Both you, Senator Brown, and Senator Kerry should be aware that there have been reported statements issued by the Los Angeles Times by Mr. Franz, which have detailed that there was a grand jury leak in 1990 of the participation of General Noriega and Munther Bilbezi in smuggling and introducing into the United States during the years 1982 and 1983 Colombian coffee through the actual records that we uncovered in our coffee claim. In other words, in order to demonstrate the falsity of the claim in 1986, it was necessary to unravel the entire previous historical commercial activity between the bank and Bilbezi between 82 and 87. I'd like to turn from our experience to some of the dangers that are posed as a result of this insurance claim and the massive, complicated federal litigation in the Southern District of Florida. What this case has demonstrated is that Bank of Credit and Commerce International was a direct financial partner with Munther Bilbezi and his companies as a continuous criminal enterprise. The bank, BCCI, gave Bilbezi the credit to do the business. The bank worked with him with the bank's capital, not Mr. Bilbezi's capital, and the bank in turn took substantial shares of that profits. BCCI prepared at all times documents which some of the exhibits will demonstrate clearly on their face, which were not destroyed and which we obtained selectively from random documents torn out of files, placed back together, that the bank itself knew through its employees and officers that the subject coffee was being smuggled. The bank used its branch network to hide the profits which were made through the coffee smuggling, through the use of cashier's checks, wire transfers, and letters of credit, all in violation of the United States Code. Without BCCI, Bilbezi would not have had a legitimate front during the years before the bank's indictment to conduct his enterprise. Now, we are deeply distressed ourselves of having conducted this litigation and the discovery since 1987. And when we were subpoenaed by agencies of the United States government to produce those records to the government, to demonstrate ongoing violations of the United States Code. Time and time again, we raised Mr. Bilbezi's smuggling activities with representatives of the United States Customs. In fact, a major meeting took place here in Washington, D.C. with Mr. Rosenblatt when we had uncovered most of the pieces of the missing puzzle. The statements which were made at the conclusion of that meeting were that the United States Customs was not interested in a paper case. a paper case that involved clear violations of the United States customs sections of the code, when we were able to demonstrate that the bank facilitated the profit made from the coffee smuggling through the bank's branches in Boca Raton by moving substantial amounts of income not reported by Mr. Bilbezi's business partners to the bank's offices in phony accounts in London, England, which were clear violations of the income tax laws of the United States. Controlling illegal activity means controlling illegal banking. This is especially true when the activity involves international continuous commerce, because that bank, the Bank of Credit and Commerce International, is illustrative of how a corrupt bank, given the power of drug trafficking, arms transactions, political payoffs, corrupt payoffs between the customers and other employees of the bank, is a bank awash and designed solely to violate the laws of the United States. It is a disappointment that with all of the information that we learned and gave to agencies of the United States Department of Treasury, particularly United States Customs, and with the information that we now know that United States Customs possessed earlier information that Mr. Bilbezi was indeed smuggling the coffee in 1983, and that Mr. Bilbezi, as of 1987, was violating the currency transaction laws of the United States, that no serious attempt was made to indict Mr. Bilbezi in the years 83 through 87. Indeed, with the information available to United States law enforcement agencies, if the indictment had taken place in the years between 1983 and 1986, the underwriters at Lloyd's would have not had to litigate a false insurance claim. Indeed, it's regrettable that the statute of limitations on the actual customs violations have all expired. And now Mr. Bilbezi is left with primarily an income tax violation, a serious income tax indictment. Thank you, Senator Kerry and Senator Brown.
Thank you very much, Mr. Doherty. Now, is Mr. Lehrman going to testify separately or just in answering questions?
He's going to be
respond to questions. Senator.
Fine. Well, I want to thank you very much for that. What I want to try to do now is see if we can draw a simpler and clearer picture, in a sense. There's a lot of convoluted history there of involvement, and for the person coming at this for the first time, it isn't that easy to follow. And I want to try to draw that picture as clearly as we can. So what I'd like to ask is, first of all, if you could, maybe Mr. Lehrman, you want to help us do this. I gather we have some documents that specifically indicate what the bank knew and how it facilitated this. And I think one of our initial points of inquiry here is to understand exactly how BCCI facilitated these two schemes. So let's take the one arms deal, where BCCI was a clear facilitator. Do you want to walk us through that?
You want us to take the charts, Senator?
Sure. Let's put the charts up. That's what they're there for, and show it in very clear terms. Mr. Lehrman, while they pull those out, why don't you just answer a question for me here verbally before they get the charts up. How was BCCI integral to the arms deal? And how would BCCI have had to have known what it was involved in?
BCCI was the conduit through which the funds to finance the arm deal were funneled. BCCI knew, Mr.
Now, what makes this arms deal illegal right up front?
The Arms Export Control Act prohibits the sale of U.S. manufactured arms without State Department approval.
Okay. Was there State Department approval here?
There was not.
And does any facilitator of financing for this know for a fact that that is required?
anyone involved in financing of arms deals would know that requirement. We have correspondence in our records reflecting inquiries that contained in BCCI's files with respect to whether the end user requirement was adhered to.
And what was the response with respect to those inquiries?
Mr. Bobasi typically evaded the response, or he said he would have that requirement taken care of.
Notwithstanding the lack of adequate response, the bank went ahead and provided the financing.
That's correct.
And if you would walk us through these charts that are up here one by one and explain precisely what they are.
The chart closest to you, Senator, is a May 27, 1987 letter from Mr. Bobasi to Brigadier General Rojas, the highest-ranking officer at the time, military officer of the government of Guatemala. In short, it says in Spanish, "We are the exclusive representatives of the Jordanian armed forces for the sale of military equipment. We also represent companies specializing in the manufacture of equipment in East and West Europe, especially Yugoslavia and Czechoslovakia." In effect, it's a letter of introduction from Mr. Bobasi to the Guatemalan government to gain an entree to the highest-ranking officials in the Guatemalan military.
The significance of that letter with respect to BCCI is what?
The significance of the letter is that Mr. Bobasi is a known arms dealer.
The next document?
The May 27, 1987 letter to Brigadier General Rojas describes a proposal for an arms deal involving Sikorsky S-76 helicopters, which Mr. Bobasi described as, quote, civilian, close quote, helicopters to the authorities regulating those helicopters and to us in discovery responses. In fact, as can be seen on page 2 of the letter, which states all of the above aircraft can be fitted with armament kits consisting of spare support reams upon which you can hang armaments to carry 50 caliber machine guns, 7.62 millimeter twin machine guns, or 2.75-inch aerial rockets, is described in an enclosure. At all times, those helicopters were to be retrofit as gunships.
And is it not true that in the course of this transaction, it was clear that the retrofitting and the provision of the military capacity was in fact part of the deal?
It was not only a part of the deal, in a way it was the only way the deal could be consummated, because had the ships been fit with armament kits prior to Bobasi supplying them to Guatemala, it would have been very clear, even clearer, that the end-user certificate requirement had been avoided. In this case, Mr. Bobasi is trying to end-run the end-user certificate requirement by providing ships with helicopters, which were always intended to be retrofit as gunships.
Notwithstanding the lack of end-user certificate, BCCI provided the requisite, or was prepared to provide the requisite financing. Is that accurate?
That is correct.
Is there any other role that BCCI played to facilitate this?
Part of arms transactions is to make sure that people in the military, highly ranked public officials, are taken care of financially. BCCI provided the conduit through which the necessary persons could be paid off. These persons would include generals, other highly ranked public officials, in this case, the brother of the then president of Guatemala, Milton Cerezo, and of course the intermediaries hired by Mr. Bobasi, including the former consul general of Guatemala.
Now, you say that very matter-of-factly. I think most Americans would sit there and say, hey, what the hell is going on here? You mean whenever there are these arms transactions, the guys in government, the guys in power get paid off? And we're basically saying, yeah, that's true. Don't be surprised, Senator. That's the way it works everywhere. Is that accurate?
Let me clarify that, Senator. In a legitimate government-to-government transaction, these type of payoffs don't exist, or at least not that we're aware of. It was precisely because this was an illicit transaction, and as Mr. Doherty stated before, for the purpose of blocking our coffee investigation in Guatemala, that the transaction was conducted not only to benefit Mr. Bobesi, but to pay the people who would be in a position to block our investigation.
Now, the third document is a reference to what?
The third document, which is a signed letter from Mr. Bobesi to Mr. Bobesi's intermediary in Guatemala, describes the spare parts that were to be provided as part of the helicopter transaction, including a list of roughly 16,000 general-purpose cluster bombs. The letter states B, general purpose, because obviously to hide the nature of the transaction. However, when Mr. Bobesi was confronted with this letter at his deposition on May 16, 1990, in the case pending in the Southern District of Florida, he did admit that B stood for cluster bombs. However, he said that the request for the cluster bombs was made by the Guatemalans, so naturally it didn't make Mr. Bobesi an arms dealer.
Senator Kerry, part of that original contemplated deal involved the sale, as we said in opening statement, of a squadron of F-5 jet fighters, and the bombs were designed as a further inducement to have the Guatemalan Air Force be on a position of parity in 1987 with a squadron of F-5 jet fighters that the State Department had approved for the sale to Honduras. But the United States State Department at all times had prohibited, as we understand it, the sale of any jet fighters or gunships to the Republic of Guatemala for what the United States State Department claimed was an ongoing violation of human rights violations going back to 1981.
That's what I want to get to. That's why, Mr. Lehrman, in the middle chart, the mounting of machine guns on these helicopters was important for Guatemala. Why? To precisely get around what Mr. Doherty has just talked about. Is that correct?
Precisely. The purpose of the end-user certificates are to ensure that only foreign governments which receive the approval of the State Department receive the lethal weaponry listed in the statute. So the whole point of using BCCI as an intermediary and using Mr. Bobesi was to permit the government of Guatemala to obtain these Northrop F-5 jet fighters and these helicopter gunships without the approval of the United States government.
Now, it's pretty fair to assume that any legitimate banking institution that wants to be in good standing understands that when it receives letters and requests for letters of credit with respect to a weapons sale, it's automatically on notice that it ought to have an end-user certificate and know that this is a legitimate and approved sale, correct?
Yes, Senator Kerry, and the first document, the very first document in the bank's file, dated January of 1983, is a letter of an introduction from Mr. Bobesi. And in the second paragraph of that letter, Mr. Bobesi boasted in English, we have an enlargement of that, of the same last paragraph 4 years later in 1987 that he was an arms dealer. In other words, the bank knew from the inception of its relationship at all times that Mr. Bobesi held himself out as an arms dealer.
The date of that is when?
January of 1983.
And in 1983, Mr. Bobesi was based in Miami, was he not?
He was, sir.
And in 1983, when he was based in Miami, he was dealing in U.S. arms. Is that not correct?
To our knowledge, he was. From the records that we received in discovery responses that dealt with all manners of weapons.
So in 1983, you have an arms dealer dealing out of Miami, holding himself out to this bank initially as an arms dealer, yet nevertheless not dealing within the confines of U.S. law.
That is correct.
Okay. Now, how exactly does the end-user certificate normally get provided? What is the process one would go through?
To my knowledge, there is a request made to the Department of State and a specific sub-agency to the Department of Munitions Control that the provider of the American-made weapons signs an end-user certificate, which was obtained in this case initially by, at the end, by President Vinicio Cerezo. There is a copy of that. But there was never any sign-off of the document of the Sikorsky helicopters, to our knowledge, by King Hussein of Jordan, who was the provider of the weapons. In any event, those documents were to be sent to the Department of State Munitions Control Board. A request was made by us to obtain that document search, and the response came back that there were none. There were none done in the deal. You should know, Senator Kerry, that United States Customs officers from West Palm Beach and an agent, Jeffrey Martin, came to the home of Mr. Bilbezi in late 1987 to confront him of the requirement of the end-user certificates and to confront him that portions of those helicopters contained prohibited equipment, VHF radios. Mr. Bilbezi then ordered that the helicopters be shipped from Aqaba, Jordan, directly to Port of St. Thomas, Castilla, Guatemala, so that the vessel never reached United States shores, so that it could be seized and that it be subject to investigation. The end-user certificates were never obtained.
Is there any other way that the committee should be aware that BCCI facilitated this process or played a role in it?
The answer to that question is yes, Senator. There are source books which we have obtained in our civil discovery. We, the attorneys for Lloyd's, are under a confidentiality order with respect to the third lawsuit in which Lloyd's has, as the plaintiff, sued the bank for a RICO action, civil RICO action. Those source records would contain the identity of corporations contained in the letters of credit file, the bank's wire transfers, and their cashier check volumes. Those documents are, of course, available to your subcommittee, and I believe from your review of it, you would be able to identify still other corporations that sold armaments from the South Florida area, or that the bank, through its branches, provided financial assistance.
Well, the committee will, I hope, issue a subpoena to secure those documents in order to try to get at that information. One of the, you just sort of flagged me on something. You've brought a RICO, civil RICO.
Yes.
Why has the government never employed a RICO attack here?
The United States government did not file a RICO action until a civil RICO action, to our knowledge, at any time. That is a matter that we addressed, and it's the only time that I personally have ever written a letter to the Attorney General of the United States, which will be later placed in evidence, in December of 1990, as it became apparent that the bank, subject to several lawsuits, was about to, having announced that it was going to retire from the United States, and that records would be taken back to Abu Dhabi, or that records would be taken back to England. And like a prophet, in one letter, one of the fifth and last letter that I addressed to the U.S. Attorney, putting him on notice with a sheaf of records of all of the possible violations and bases to bring a civil RICO action, I reminded the U.S. Attorney and the Attorney General of the United States that under the United States Code, they possess the power under the civil RICO statute to issue what is called a civil investigative demand and seize the records of the bank before those records were taken back to the Middle East, so that the United States Justice Department could conduct just such an inquiry and find out whether or not, from the branches in Miami, Boca Raton, Los Angeles, Tampa, New York, or Chicago, major arms transactions had taken place in Central America, and we received no response to that. In other words, I felt it necessary, before my clients authorized the filing of a RICO claim, to bring to the attention of the U.S. Attorney and the Attorney General himself of the fact that they possess the power of greater magnitude than the underwriters at Lloyd's as a civil plaintiff to seize those records, and no attempt was done. As soon as My clients initiated a RICO action. We immediately sought from the United States Magistrate in the Southern District of Florida, Magistrate Johnson, orders to seize the records as in January the bank announced its close down. We were successful in obtaining a series of orders in the civil litigation in which Magistrate Johnson and later United States District Judge Marino ordered these source records seized and made available to us, subject to this confidentiality order. To answer your question, I don't believe that the U.S. Attorney's Office has ever done it. We could only speculate as to the reasons why they have not done that. I myself, which I don't think would be appropriate.
Let me ask you for your short answers here on a couple of things. You keep putting your hand on this book and demonstrating. What is that you were referring to?
I wanted to...
Is that what you sent to the Justice Department?
We have those letters here. I wanted to show you, Senator, and I have it, the actual orders themselves that contain the orders prohibiting the removal of the records, and we have an index of a series of correspondence that we'll deliver to you.
I'm trying to get the sequence here. You began, as you went through the investigation, 87, 88, you began to collect more and more information. You said there were 4 times, 5 times you were in touch with the law enforcement authorities?
Yes, we have an index of those letters sent to the United States Justice Department.
What was the date of the first letter?
First letter went September 13th, 1989 to the District Director of U.S. Customs in Tampa.
Setting out what?
A request for records that would demonstrate coffee smuggling by Coffee Inc. and asking Customs if they would permit us to receive those records.
What happened to that?
No response.
What was the next correspondence?
The next correspondence in sequence went to the Assistant U.S. Attorney, Louis Kerry, and then on November 29th, 89, to the U.S. Attorney. The U.S. Attorneys in both Miami, New Orleans, and Tampa, bringing to their attention the existence of the coffee smuggling scheme and a request to receive records in the possession of U.S. Customs. No response.
Now, okay, no response at all.
None.
And then the next correspondence?
Next correspondence was on December 15th, 1989. It was a letter directed to Mr. Flynn to attempt to...
Who is Mr. Flynn?
Mr. Flynn is an assistant U.S. attorney here in Washington, and that dealt with the inquiry as to whether or not there were any end-user certificates issued to Mr. Bill Basie or his corporations for the Guatemalan transaction or any of the previous ones, and there was a response that the appropriate Department of State agency, munitions control, had no such records of Mr. Bill Basie.
What was, and then you wrote another letter subsequent to that?
Yes, we wrote a letter on April the 30th to the Assistant U.S. Attorney, Mark Chakowski.
April 30th, what year?
1990, asking for a request to review specific records that were introduced in the BCCI criminal indictment and the criminal conviction in Tampa, and an opportunity to confer with him and to review the records that were seized from BCCI in Miami under a search order that was issued by the United States Magistrate when the bank's offices were all, their records were seized.
What happened to that request?
No response.
Well, is it possible, I mean, being devil's advocate and taking their side for a minute, is it possible that they had an ongoing investigation and didn't want to deal with somebody on the outside at that time?
Well, the records we wanted to see, Senator, we wanted to confirm were the records of Munther Bill Basie that were also seized at the same time that the grand jury subpoena and search order was issued. In other words, when the Operation Sea Chase indictment occurred, there was a seizure of bank records, including Amjad Awan's records when he was in charge of LACRO in Miami. And part of all of his customers included not only the individuals
I'm not sure that answers my question. I mean, there was an ongoing investigation at the time, correct?
Well, the records that we wanted to see were the records that were either not used by the Middle District Attorney's, U.S. Attorney's Office that were taken, that should have been available to us.
I see.
And we should have been given an opportunity to see the records that were put in evidence, and we weren't allowed to see those either.
Now, and what was the last letter you referred to?
That was a letter of April 30th, 1990 to
Was there a subsequent letter?
Next letter went to Bonnie Tischler on May 4th, 1990 from U.S. Customs Service, because we were requesting at that time to meet and confer concerning the ongoing investigation that we had to prove and establish in our civil case the existence of a...
Well, what I'm trying to get at, these are, some of these communications that you're referring to seem to be requests for information. But in your testimony, you say, as officers of the court, we considered it our duty to bring these crimes to the attention of appropriate law enforcement agencies. Over the next 3 years, we repeatedly notified the Customs Service, IRS, and the United States Attorney's offices of 3 districts of these crimes. Finally, in frustration, I sent a letter to the Attorney General outlining the problem. Now, those aren't the letters you've just referred to.
No, sir. The letters, the first notice went out on November 29th, 1989.
And that was a notice of what? Of crimes?
Of the existence of those crimes.
Did you have any response to that?
None.
Was there any response with respect to those crimes, investigatively or otherwise?
None. The only agency that contacted us for that responded was the Criminal Investigation Unit of Internal Revenue Service, which did subpoena portions of our records. I do not know if the U.S. Attorney's Office in New Orleans or Miami then referred the inquiries we made to IRS. But at all times, the only response that we ever received were subpoenas issued by the Internal Revenue Service.
Now, you say you sent a letter to the Attorney General. What was the purpose of that letter?
Senator, the purpose of that letter was subsequent to the request for a conference with Mr. Rosenblatt, which occurred in August of 1989, because as I testified in my opening statement, that conference in which we laid out to him all of the information that we had acquired in 87, 88, and through the summer of 89 for the clear violations of customs violations. All of the documents, money laundering, income tax violations. As far as customs was concerned, and Mr. Rosenblatt, it was a paper case, had no glitz, they were not interested in it. It then became apparent that because of more information that we received in the summer of 1989 and in 1990, that the manner in which the bank moved money for Mr. Bilbezi and his former partners was a common method used by still other customers whose records we had access to. And we wish to use, under Federal Rule of Evidence 404B, evidence of similar conduct. And here we are with the bank about to leave the United States and the records going. We're asking in advance the assistance of the Justice Department to initiate, if they're not going to file a RICO claim, to at least seize the records before the records go.
And they didn't seize the records?
They did not seize the records. They did not respond to the letter.
Did records go? Did you lose records as a consequence?
Senator, we believe so.
But you don't know?
I don't know that, but I do know that a major fire took place in London, England, and a large source of those bank records were, quote, burned about 3 months ago. I know that from speaking to various witnesses who have testified that bank records were moved out of Miami and Boca Raton back to England.
Okay, now let me ask again my question. What was the purpose of the letter to the Attorney General?
Purpose of the, and I wish that we had that letter here, Senator. I'd like to come back to it if we could after lunch, because it'll be provided and I can give you a copy of it. And
well, I'm not sure we're coming back after lunch.
I'm sorry. I'll provide those letters to you.
Where is that letter?
It should be in your office right now because it was sent Federal Express.
Is this all the documents that you...
No, it's a small package of the specific letters.
All right. Would you have somebody check if that letter, if those documents have arrived? Because I'd like to... Do you have any of the letters that you sent to the various departments there?
I provided them to your office, Senator, and we couldn't locate them yesterday, so I asked for an additional set, and they were sent yesterday, Federal Express, and they should be here now. I have the chronology of them, but we have a hard set for you.
What is the chronology? Do you have that in paper there?
Yes.
Is the clerk here? Would you collect those? I'd like to put those into the record at this time, and without objection, I'd like to put the other documents into the record in sequence as we get them now, and we will make those available.
Senator, I have some of the copies, and I have the index here. Richard provided them with me.
Well, if you could give us the index and the copies that you have.
And if I could, here is the specific letter of December 12, 1990, with a copy to the Attorney General of the United States.
All right, could you read that? I'd just be interested what you said.
Yes. This letter was written on December 12, 1990, to the U.S. Attorney in the Southern District of Florida, Dexter Lenathan.
No, that's not the one I'm talking about. I thought you said you had the one to the Attorney General.
Yes, it shows a carbon copy.
Oh, I'm sorry. All right.
Dear Mr. Lenathan, I enclose for your review the following. 1. A copy of my correspondence to you and Robert S. Sabursky, U.S. Customs, Tampa, and John Volz, United States Attorney, New Orleans, dated November 29, 1989, outlining the essential elements of the illegal activities involved in the above referenced litigation, Exhibit 1, and we gave him all the records. 2. A copy of the letter from the Secretary General of the Republic of Guatemala and personal attorney to the President of Guatemala, dated December the 7th, 1990, seeking your assistance in cooperation in a matter of great importance to the government of Guatemala. And that was a request to have Mr. Bilbezi extradited to Guatemala if he came to the United States. 3. A copy of an article appearing in the South Florida Business Journal for the week of October 1990, entitled "Insurance Claims Reveal a Web of Intrigue. Former Boca businessman Bilbezi in a Guatemalan arms deal, coffee smuggling." In other words, we're waving the red flag. Hey, here is a complete newspaper article outlining in simple form the entire caper. 5. A copy of the motion for summary judgment filed by Lloyd's based on illegality. Judge Marcus has not yet set oral argument on the motion. This motion reviews all of the classic elements of multiple violations of the United States Code involving customs violations, and I identify the code sections, fraud, and false statements. Why? I'm telling them that I know that the statute of limitations is going to expire. 6.
And just to make the record clear, the statute of limitations did expire, is that correct?
And then it subsequently expired.
Correct. All right.
6. A copy of a proposed RICO complaint to be filed on behalf of my clients seeking money damages for multiple RICO violations under Chapter 18, 1964. We have received a series of subpoena duces tecum to produce our files and all of our databases, which have demonstrated clear, continuous, multiple instances of laundering of money instruments in violation of Title 18, all committed by various officers and employees of Bank of Credit and Commerce International. We understand that this matter is presently assigned to your Assistant U.S. Attorney, Andres Rivero. As you are aware, Judge Hodges of the Middle District of Florida has sentenced bank officers of BCCI after accepting from that bank an agreement entered into with the Office of the U.S. Attorney of the Middle District, a $15 million fine. We have uncovered still further evidence of money laundering, kickbacks, extortion attempts, and continuing multiple violations of obstruction of justice made by officers of the Bank of Credit and Commerce International, their attorneys and investigators here in Miami. Since your office possesses the power to file or make recommendations of civil investigative demands under Title 18, 1986, to expedite this matter, and under 1966, allowing the United States government to recover money damages, we are requesting, underlined, an immediate conference to bring these matters to your attention, and then I say in caps, prior to the further attempts of Bank of Credit and Commerce International to destroy records or remove records from the jurisdiction as contemplated by the withdrawal of the bank from the state of Florida before January 11, 1991, with a Federal Express copy of all of the records and a shown copy of the letter to the Honorable Richard Thornburg, Attorney General of the United States, to which we received no answer.
So you were never contacted for that meeting?
We were not.
You never had that meeting.
We never did.
Now, there's a whole area of the coffee smuggling and more in the arms, but I'm going to cede to my colleague at this point. I've gone considerably longer than I intended.
We have
Senator
these
Brown.
letters here, Senator.
Those letters are now to be made part of the record, and we'll put them in a sequence that the package is made available to the clerk.
Thank you, Mr. Chairman. I'm not sure if Mr. Doherty or Mr. Lerman is the appropriate one.
Do you want to do the coffee smuggling in peace and lay it out? Or do you want to, you got an area you want to go into?
I wanted to get the arms to straighten out. Just to backtrack a bit, an end-user certificate is required by U.S. law for the export of arms.
For the export or the reintroduction or the subsequent sale of a United States-made weapon, yes.
Okay. So there's three requirements here. If it's exported, or if it is reworked, or if it is resold, U.S. law requires an end-user certificate.
That's my understanding of United States law.
And thus,
The purpose
review by
being-
munitions control and an approval of that
That's correct,
sale.
Senator.
Okay.
We keep a track on our major weapons so that the movement or subsequent sale of them will not interfere with the United States State Department policy or the policy of the United States government.
Now, in this instance, Jordan was interested in selling arms through this agent to Guatemala.
Yes.
What obligates Jordan to obtain an end-user certificate or seek U.S. approval to resell those U.S. arms?
As I understand, if it's a direct government sale by the Hashemite Kingdom of Jordan to the Republic of Guatemala, the seller, Jordan, would be required to obtain State Department approval of the sale.
Now, how required?
It's mandatory.
They have agreed as a condition of getting a certificate themselves?
At the time of the original or initial sale of the Sikorsky S-76s as any major American-made weapon, they are obligated, the recipient of the weapon, to confirm and acknowledge that upon the resale of that equipment, there must be an end-user certificate, and that sale must be done with United States State Department approval.
Now, in this case, Jordan did not obtain that certificate
To our knowledge, it did not.
and did not, as far as we know, even apply for it.
To our knowledge, it did not. Munitions Control Board has no record of those records. They
So-
did a record search and represented that there are no such records.
So what we have here is Jordan has violated its agreement with the United States with regard to resale of U.S. arms, and BCCI appears to have entered into a conspiracy to violate, or at least to accommodate the noncompliance with that agreement.
That's correct. And there's one other factor. At the time, Senator, that was being processed, Munther Bill Basie owed BCCI over $3.5 million plus interest for this overdraft facility where he could write all the cashier's checks to buy the coffee. In other words, Bill Basie, in debt to the bank, Coffee Inc., owed the bank in 1987 $3.5 million with interest. And there are in the files repeated demands: pay the money or your security in Jordan will be forfeited. The security is not forfeited. It's much like a person who is in debt to a lender, then goes to the lender and enters into an arms transaction.
What was the security that Bill Basie had tied up in Jordan?
They were a series of CDs, which ultimately the bank did call upon and which were paid, so that the security in certain banks in Switzerland or in France or in Jordan were paid to BCCI Miami, leaving an unpaid difference of approximately $500,000.
Senator, could I just add to that? The security was basically a bank guarantee issued by BCCI Amman, we found a substantial level of correspondence between BCCI Miami and BCCI Amman. So all of the arms deals and all of the coffee smuggling took place essentially financed by BCCI Amman, although all the documentation purports to show that it was conducted through a BCCI Miami account. And in fact, Exim Bank, to a certain extent, financed the sale of the 3 helicopters.
How could Exim Bank finance something and not insist on an end-user certificate?
By the use of the euphemism, quote, civilian helicopters. I would assume that there was constant
The
telex-
sale was represented as as being exempt from the end-user certificate requirement.
Apparently, that these were at all times civilian helicopters used by the king with mahogany, and they're alternatively to be used for 3 helicopters sold to the Republic of Guatemala for $5 million as alternately ambulances, and that was their true intention.
May I add something, Senator?
Just one insert. What shows that BCCI knew that, if that's a key question?
We have the bank files that would indicate that there, from the exhibits that you have, that we have here, previously, the bank was aware during coffee smuggling that there was an absolute requirement from Munitions Control Board that there be proper certificates for an arms transaction. We have that. So they knew in 1984 and in 1985 the necessity for United States approval.
Senator, if I could amplify that by directing you to the enclosures to the exhibits in enclosure number 1, there was a handwritten memo.
We'll get one for you.
Just hold on one sec. We're going to get those for Senator Brown and myself, so we have them.
Is this the one you're referring to in 5?
Yes.
Okay. This is a memo that involves a handwritten note that they felt they did not have an obligation to notify the U.S. Customs Service
That is correct.
if for illegal activity unless it related to arms or drugs?
That is correct. The memo was written in a different context to cover up.
Why don't you help us and those who are watching who don't know what we're doing here to just tell us what this is. And
I direct your attention to the chart closest to you, which is a handwritten memo signed by Grace Perez. That is the second page of a handwritten memorandum on top of a letter from Munther Bobesi. Show page 1. No. In the course of smuggling the coffee, which was done through these documentary letters of credit, Mr. Bobesi was constantly advising the bank to, at the last minute, change the destination from Aqaba, Jordan to Miami. Finally, one of the bank officers, who is apparently out of the loop, handwrites a memo on top of Mr. Bobesi's request to change the letter of credit to reflect a different destination, that is Miami, Florida, rather than Aqaba, Jordan. And this bank officer says, in effect, it's
just
not...
why don't you read it, precisely what the bank officer says.
In the bank officer's handwriting, it says, as per regulations of United States Customs, all coffee imports into the USA are subject to validated release by U.S. Customs and inspection by the U.S. Food and Drug Administration. As per Article 8A of the ICC publication, and references a specific publication, quote, in documentary credit operations, all parties concerned deal in documents and not in goods. I have consulted with my counterpart in other New York banks, and they are of the view that it is not the bank's duty to monitor quotas. If a non-quota item is entering the USA, it is U.S. Customs who will hold or release goods, etc. The second page of the document is a memo dated the next date that indicates this bank officer spoke to someone in New York from the Council International building who confirms that, quote, banks are not to monitor or to be responsible for quotas of commodity, that it is the importers, in this case Mr. Bobasi's responsibility, and that in our security agreement it stipulates that they assume this responsibility to meet U.S. Customs laws and regulations. Quote, the only commodity we should be aware of is that of arms and explosives.
In other words, if the bank is aware of shipments that violate U.S. law, their position was that they had no obligation to advise U.S. Customs of that violation.
According to this memorandum, that was the position of this bank officer.
Let me take you back, if I could, on the arms shipment. Arms were sold to Jordan. They obtained an end-user certificate, and Jordan agreed to obtain an end-user certificate if it resold those arms.
As a condition of purchasing those
As a
arms.
condition of purchasing. Jordan, through a criminal agent, and in conspiracy, in concert, I guess, with BCCI, resells those arms without an end-user certificate.
That is correct.
There is evidence to show that BCCI and the agent and Jordan were aware of the fact that they had not had an end-user certificate
Yes,
in
there
selling
is.
that.
Yes.
Is there any indication that Guatemala was aware of the fact that they were buying arms without an end-user certificate?
Yes.
Has the U.S. State Department, to your knowledge, raised this issue with the governments of Jordan and Guatemala?
Not to our knowledge.
Excuse me, Senator Brown, to our knowledge, the customs agent in charge of it, Jeffrey Martin from U.S. Customs in West Palm Beach, had a meeting with the assistant U.S. attorneys in Miami and recommended criminal action. And the reason I know that is that from the same airport where the 18 Sikorsky helicopters were, 12 of which were to go to Guatemala, 3 of which did go to Guatemala, 3 of the same S-76 helicopters were from the same group, same airport, same manufacturer, attempted to be sold in 1989 to the government of Iran. And an Englishman by the name of Colin Breeze attempted to take those helicopters, have them changed to gunships, and sold to Iran. And work was to be done in the United States. Colin Breeze came to West Palm Beach, Florida, and he was arrested. And by coincidence, he was tried before Judge Stanley Marcus, and after a jury trial and he was convicted, he was sentenced to at least 10 years in prison. And Jeffrey Martin testified in court, and since they were the same helicopters that came from Jordan and they were going to Guatemala, we were interested to see the actual people who were testifying in front of the same federal judge. And the individual from the State Department Munitions Control Board testified together with Jeffrey Martin. So here we have, although it was a clear violation of United States law that American-made helicopters are going to Iran, for which a person was arrested, we had the issue then was their compliance when the same helicopters going from Jordan, same batch, were going to Guatemala. So it became clear that at least the agent charged with the Breeze indictment, who became involved in the Bilbasi investigation, felt strongly enough to state to the assistant U.S. attorney that an indictment take place, but it never happened. And at all times, and during 1988, certainly the U.S. Attorney's Office was aware from the correspondence that you have of the combination of Bilbasi and the bank financing the helicopters, the bank financing the smuggled coffee, and nothing happened.
Mr. Chairman, I would like to ask unanimous consent at this time that this subcommittee ask the staff to prepare a letter for the signatures of this subcommittee, or the address to the Secretary of State, reviewing the evidence of the violations of the apparent violations of the agreements under arms control procedures by Jordan and by Guatemala, and asking for a State Department investigation of this report and appropriate follow-up with the governments involved.
I think it's a very good idea. I think it's appropriate, and without objection, so ordered, and we will do so.
With your permission, Mr. Chairman, I'd like to pursue just briefly the coffee aspect.
That's an area we want to get. Just before you leave the arms, can I ask your indulgence to yield to me for a minute? And I want to just complete one thing on the arms. In packet number 2, defendant's exhibit number 10, as it's labeled within that packet. Excuse me, it's packet 3, not 2. Packet number 3, defendant's exhibit number 10, there is a memorandum to Monthor Bilbesi from Alberto Capo. Would you explain to the committee what that memorandum is and what it purports to set forth?
Yes. Senator, in one of the 3 cases involving Monthor Bilbesi, the fine arts claim in West Palm Beach, continued demands were made to have Mr. Bilbesi's counsel and Mr. Bilbesi, who had fled to Jordan last summer, produce records to establish that he was an arms dealer. Finally, his latest attorney, Mr. Arthur Koski, in Palm Beach, filed a series of documents in which this was contained. This document is a memorandum prepared by Alberto Capo, who was a vice president of Mura International, and it was sent to Mr. Bilbesi, and it's contained in the discovery request showing correspondence between Bilbesi and his employees under the name Mura. And it describes what occurred in October of 1988 when Mr. Bilbesi was in the process of sending, at his own personal expense, an entire delegation of the Guatemalan Air Force from Guatemala through Miami and New York to Amman, Jordan. He paid for that so that the Guatemalans could inspect both the helicopters and the jet fighters. The memo states, please be advised of the following. The purpose of the Guatemalan Technical Commission is to inspect the 3 units that were purchased in the contract with Bilbesi's company, Mura International. In parenthesis, they will also inspect the 10 units they intend to buy. 1. Royal Jordanian Air Force 719 VIP, King's personal helicopter, King Hussein's. 2, Royal Jordanian Air Force VIP with low hours in good question. And 3, a medical ambulance. These 3 must be ready for inspection and testing by commission. That is the Guatemalan Commission. And they can already be painted or done during the time the commission is there. Also needed is the list of spare parts, with the price covering $1,375,000. We can include in the list ground support equipment, tools, and any equipment necessary. To collect our money, we need to have Royal Jordanian Air Force prepare, Senator Brown, a bill of sale transferring property, 3 units, from the Royal Jordanian Air Force to the Republic of Guatemala. Next paragraph. Regarding the assignments, we have already covered the following. $400,000 to BCCI, in parenthesis MB.
What does the MB stand for?
Well, it stands for Monthor Bilbesi, and the question is what was going to be done with the $400,000. We know what now happened with the money in Guatemala, and the question is, was any of that money distributed by Mr. Bilbesi to members of the Royal Jordanian Air Force as it was distributed to members of the Republic of Guatemala? $270,000 to the President's brother, Milton Cereza, the President's brother, it's referring to, in context, the President's brother, referring to the Republic of Guatemala. $17,500 to J. Valdez. $150,000 to Mauricio Coronado, MC, and Luis Altamar. Still
And
needed
they
to...
are, in terms of this transaction, what does that mean?
Valdez was then an employee or a member of the Guatemalan Commission. Coronado and Altamar were the original brokers on the deal, who Mr. Altamar had smuggled the coffee from Mr. Bilbezi in Honduras and Guatemala in 85, 86, and 87, and Coronado was the former consul of Guatemala to Miami who worked with Mr. Altamar to put this deal together.
Could that have been a legitimate broker fee to them?
In the opinion, could that be a legitimate broker fee? Well, that was their confirmed piece of the action. That was what they demanded in order to introduce the Bilbezi crowd to the Guatemalans.
Well, that's often paid for, isn't it?
That is a frequent, much like a real estate broker commission. Two people agree as to what their commission
So there's not
will-
necessarily anything of
illegal nature.
in that.
No.
But obviously of great interest is the payment to the president's brother, the payment to the BCCI, and subsequent to that, the payment to two generals, correct?
Yes, still needed to be paid $517,000 to the Bank of Guatemala for a performance bond, and then it states $150,000 to the two generals. That is a crime in Guatemala, and a separate representative of the Republic of Guatemala has traveled here and has the criminal indictments that have been filed against the former president of Guatemala, his brother, and the generals, as well as the subsequent new indictments filed against Bilbezi for unpaid coffee customs duties.
Let me just say for the record that each of those packets has now been placed into the record as in sequence, and so all of that is referenced formally to part of the record. Senator Brown, thank you for your yield.
Just to help me put a cap on this, what you've just quoted to us makes it appear that BCCI not only participated in a conspiracy to violate the U.S. Arms Export Control Act, but even participated in arranging for criminal payoffs.
That's true, and there's one more.
Jim,
This is indeed a full-service bank.
The third aspect of this was that the bank knew, because of the subpoenas that were served on the bank and the requests made by Mr. Bilbezi to produce records, that there was an investigation into the coffee smuggling. In 1987, there was an investigation to determine whether or not there was an insured loss in Guatemala. That was going on in October. That was all ongoing in 1987, Senator. And in 1988, Lloyd's was
Excuse me, the investigation was being done by who?
representatives of Lloyd's. So in 1988, we're in litigation in the Southern District of Florida in the federal court. And Lloyd's has issued subpoenas against the bank to produce records. These records were not produced that referred to on their face. The cashier's checks, they weren't produced. What I'm saying, Senator Brown, is there was a financial motive for the bank after the insurance claims were filed to join with its customer, Bilbezi, to block the investigation in Guatemala by participating and funneling the money corruptly to these individuals in Guatemala to secure favor, to prevent an adequate investigation, so that not only would the coffee claim of the 86 shipment not be uncovered, but all of the previous illegal shipments.
So the bank participated in violation of the Arms Control Act. The bank participated apparently in planning and delivering bribery payments. And they also participated in covering it up.
That's what I believe occurred. And they had participated between 83 and 86 in the ongoing coffee smuggling, be it in Honduras, Guatemala, or Panama. So it was of great financial interest for the bank, once Mr. Bilbezi filed the insurance claim, that all of the illegal shipments from 83, 86, and 87 not be uncovered. And one way to do it, why would Mr. Bilbezi pick, of all of the countries that he had previously sold weapons to, South Africa, El Salvador, Honduras. Why would he pick Guatemala to sell, quote, civilian helicopters to in 1987 after the coffee claim had been filed? And the most direct substantive answer to that is to obstruct justice, corrupt public officials, and block and impede with the Minister of Defense of that country, with the President of Guatemala's brother, and uncovering that that claim was false, which would have led to the uncovering, which we have found, of all of the coffee smuggling.
Well, let's go back to the coffee.
Before we do,
May I,
follow up on-
Senator, could I explain one thing? If it wasn't for BCCI involvement in the helicopter deal, there would never have been any helicopter deal in Guatemala. And the reason was that they needed the financing. And who supplied the financing? It was Exim Bank. And how did they do it? Through using a third bank in the middle by obtaining the financing. And if it would have been an Exim Bank deal with Capital Bank, which is the way the letter of credit at first started, without the end user certificates, nothing would have gone down to Guatemala. BCCI got involved in order to avoid the end user certificates in this deal.
This is a point where I want to just put into the record, if there is no objection, what is known as the Philip Manuel Resource Group report, which is a report of an internal investigation of Munto Bilbezi and the Boca Raton IRS, so forth. This was a report, it's a private detective report that was put together and prepared for the law firm of Holland and Knight. And the report covers BCCI role in the smuggling operations. This is a report which I take it you gentlemen have not seen previously, but which
We have not seen it.
this committee has gained access to. And I'm going to put the full report in the record. And I just want to ask a few quick questions about the report. On page 3, the report says, and I quote from it, "As with any smuggling operation, the operatives have several essential needs. They required a secure, safe system of financing their transactions. They needed appropriate extensions of credit in the form of loans and overdrafts without too much formality, and they required a flexible system of payments to their foreign associates in Central America, whether by wire transfer or cashier's check or both. Moreover, their import and shipping documents were necessarily incomplete or defective, and so the smugglers needed unquestioning acceptance of these items in order to ensure prompt, safe payment to their associates in Central America. The BCC, Miami, and Boca Raton agencies accommodated these needs." So essentially, to come back on what Senator Brown was saying, this report, while as you will testify, I think this report has a slant purposefully and is not accurate in all respects. This report does set forth what the needs of these smugglers were and why BCCI was so important to them. Is that accurate?
Well, Senator, we haven't seen the report. It's flattery to us that the bank's own attorneys and investigators came to the same conclusion.
Let me ask you a couple of questions with respect to the report, if I can. The report suggests that Bilbezi had a partner in his operations and that that partner, Gerardo Harris, was a close associate of General Noriega. Do you know that to be true or not?
We haven't seen the report. I know it to be
No,
true.
do you know it to be true that he had a partner?
I know it to be absolutely true.
All right, so he did have a partner?
Yes.
And the partner was a close associate of General Noriega?
Yes.
Okay. Do you know whether or not part of Bilbezi's profit was sent to Gerardo Harris in Panama?
Yes, we know that because we have the actual checks written by Mr. Bilbezi.
And the report suggests on page 151 that in 1984, Bilbezi transferred $560,000 from Coffee Inc. into Gerardo Harris-controlled accounts. Is that supported by your documents?
It is, from the documents produced by Mr. Bilbezi and his counsel. And that was the connecting link.
Now, I'd like to ask Mr. Lehrman just a couple of quick questions before we move into coffee, which Senator Brown is going to present for the committee. It's my understanding that BCCI is now under the control of receivers who have been appointed by the central banks of the various countries. Is that correct, Mr. Lehrman?
There are provisional liquidators.
Provisional liquidators.
That's correct.
Okay. And have the liquidators made any effort to track down the BCCI inside borrowers and to recover the money that they borrowed from BCCI, which is among the missing money?
Senator, unfortunately...
No, I just want to ask Mr. Lehrman, can
I will, sir, but you understand that a bankruptcy judge in New York has imposed, at the request of the bank, a gag order or a confidentiality order on that. Now, why that was done, why they requested that, I do not know.
Well, let me understand this correctly. A bankruptcy judge, this is the one that I think this committee criticized. I criticized, and we wrote a letter, I think, and filed an affidavit with the judge.
That's correct.
Now, you're telling me that but I think the gag order applies as to not the process, but as to substance in front of the court, does it not?
That's correct.
Well, I'm asking you about process here. What I want to know is whether or not the liquidators have made any effort to track down the inside borrowers.
The short answer to that, Senator, is no.
Do you know why not, or what they're waiting for?
They've indicated that they are attempting to pursue an agreement with the Abu Dhabi government or an unnamed Abu Dhabi entity in order to make a contribution to the bank to, quote, restructure, close quote, the bank so that the bank can once again function.
Well, now, the liquidators are working really on behalf of the creditors. Isn't that accurate? The liquidators represent the creditors.
That's correct.
And there are a lot of creditors out there who think they have some money coming to them, correct?
That is correct.
Now, the liquidators have an attorney-client privilege, do they not?
Yes.
Have the liquidators waived an attorney-client privilege so that the creditors on whose interests they are supposed to be acting can investigate the fraud that has occurred?
No, sir, they have not. They've instructed their attorneys not to waive that privilege, and I would add that it's rather common in bankruptcy proceedings involving fraud for the privilege between the client committing the fraud and former counsel to be waived by the trustee.
I might add that Mr. Clifford and Mr. Altman have invoked an attorney-client privilege to prevent the subcommittee from obtaining certain documents for I'm concerned that there's a sort of potential conflict here, which I want to get at for a minute. Now, are the liquidators resisting your discovery efforts?
That would be the understatement of the year.
Now, why do you think they're trying to keep these documents secret?
For one reason, we are pursuing a racketeering claim against the bank, which is now becomes the estate. To the extent that we can document our racketeering claim, there's less money in there for the estate. That is inconsistent with the duties of a trustee, which is what these provisional liquidators are analogous to.
Well, are the liquidators requesting protective orders to avoid public disclosure of BCCI documents?
Yes.
Have orders been granted?
Yes.
Why? Why should these documents be kept from public disclosure?
The purported rationale is that these documents contain sensitive information which the liquidators haven't had a chance to go through yet, and that disclosure would somehow endanger the status of the bank. In our litigation, the counsel for the bank resisted disclosure on the grounds that disclosure would reveal confidential customer information. And the liquidators say that the creditors of the bank, the $20 billion worth of creditors, are the customers of the bank. It's been our experience, our limited experience with bank customers, that the very same bank customers whose confidentiality sought to be protected by former attorneys and now by the present provisional liquidators are the very people who committed the crimes that closed the bank down in the first place.
Would you say that the liquidators have a conflict of interest with the Bank of England?
That would be our judgment.
Why do you say that?
Because on one hand, the liquidators were appointed by regulators in 3 jurisdictions in which the bank was headquartered, precisely because of the, quote, widespread fraud, close quote, perpetrated by the customers, management, and shareholders of the banks. These are the very same people whose interests, to the extent that the liquidators seek to block disclosure, that the liquidators are protecting.
Well, it disturbs me that the liquidators should continue to lose lawyers who worked for BCCI as part of the legal team in this process. It seems to me to be a very direct conflict. Am I?
Well, our understanding, we've been advised by counsel for the Republic of Panama, which is pursuing a parallel racketeering action against BCCI for BCCI's alleged efforts to remove General Noriega's money from or rather the Republic of Panama's money into Swiss bank accounts in Noriega's name, that attorneys hired by the provisional liquidators have now taken the legal position that 2 of the 3 BCCI entities have no jurisdictional connection with Florida. On the other hand, in the confidential proceedings, there are documents submitted by the provisional liquidators which are subject to the confidentiality order, which take the exact opposite position. I can't reveal them.
Give me a simple layperson's explanation of what's at stake here. I mean, could American creditors be shortchanged as a consequence of the bankruptcy proceedings in New York?
Again, shortchange would be an understatement. The whole point of the proceedings in New York is to remove all of the assets of BCCI in the United States and bring them into a central location in a foreign jurisdiction where allegedly the money would be parceled out to all the creditors of the bank, who include the very customers who committed the frauds that closed the bank down in the first place.
You have well articulated the nub of this thing, which is very, very disturbing. I mean, you've got a legal proceeding in New York that may in effect frustrate American creditors as well as enrich the very people who committed this crime in the first place. Is that accurate?
I couldn't argue with that.
And the legal process is in fact standing in the way of our ability to get at the truth and to be able to try to protect the interests of the smaller person.
31st, 1991. We came back to our office, I think on a Thursday after a Wednesday hearing, and got a 150-page fax from Sherman and Sterling commencing the bankruptcy proceeding. At great expense to protect the interest of underwriters, we participated in the bankruptcy proceeding. You're aware of it. Depositions were scheduled, accelerated discovery. When the depositions were scheduled, the United States Attorney's Office in New York didn't even go to the deposition. Sent a letter saying, we're not coming.
Well, I tell you, the people's lawyer is supposed to be the Attorney General, and we've got a lot of different layers of people's lawyers in this country, between U.S. attorneys and district attorneys and so forth. Somebody ought to be taking note of the way in which the public may once again be victimized in this process. And they ought to be raising a hullabaloo about this and trying to guarantee that whatever liquidation procedure takes place, that criminals are not going to be enriched by it, and that the appropriate protections are going to be put in place to guarantee that the citizens of this country are not going to be out another buck as a consequence of this. I've stolen more time than I meant to, and we wanted to look at the coffee scheme, and Senator Brown's going to present that.
Thank you, Mr. Chairman. I wanted to backtrack a little bit on coffee. As I understand it, with the International Coffee Organization, during this period of time had a functioning agreement that attempted to allocate the market by setting quotas for production or for export sales from a variety of countries, and dealt with quotas that might be purchased by importing countries. And that the key enforcement mechanism here, if I understand it, is a certificate of origin for the coffee, which the receiving country then keeps a tabulation as to how much coffee has come in from that country and how much is allowed. Is that a fair summarization of how the mechanics work here? There's an agreement that allocates production and consumption, production and importation, and that the receiving country has to see a certificate of origin and then keeps track of how much has come in?
Senator, the agreement, what it does, it allocates quotas to the producing countries. It does not allocate quotas to the consuming countries. The producing countries, based on the quotas allocated, send it to those to the consuming countries that are members of the agreement.
Who keeps track then? Who keeps track, and how do you keep track of whether or not the producing countries have overshipped their allotment or their quota?
The ICO in London receives from the importing country the certificate of origin back, and they are the ones who keep track.
So anytime coffee, for example, during this period would come into the United States, a certificate of origin was required, and that information then was communicated back to the ICO.
Correct.
Okay. How was it that they were able to bring coffee into this country without a certificate of origin?
That is because they use a completely different system. They smuggle the coffee out of those Central American countries, and now we can show you through the displays that are up in the board, the color displays, that is, how these people were able to manipulate the quota systems in Central America and into the United States.
But I would appreciate that if you would focus on two things. One, how they got it out without a certificate of origin, and two, how they got it in here without a certificate of origin. Mr. Lerman or whoever wishes to.
Certificates of origin are for presentation.
Mr. Lerman, can you help us with that quick summary of?
You want me? I'll do it.
Yeah. Mr. Lerman, could you go up to the board and explain, and take the mic that's farthest over there and just drag it over with you. Mr. Lerman, if you just pick the mic up, there you go, right there at the end. You can just do it and sort of hold it sideways, stand at the end of the table, just pick the mic right up in your hand here, and you can explain it, and Mr. Valls can hold the card for you. There you go. Pick them both together. Both mics, just take the whole thing. There you go. All right. And Mr. Valls, that's about as far as it goes. So if you stand on that side, Mr. Valls, would you go over the other side there? That's it. Now we're getting coordinated. Okay.
There's a certificate of completion of the education program to testify before the committee.
And if you can hold them a little sideways, maybe some of the members of the media can also follow that. Both ways. Okay, go ahead.
To understand how coffee was smuggled into the United States, you have to realize how it was shipped into the United States. The coffee is shipped in containers not quite the size of this room, but almost as big, approximately 8,000 cubic feet. In international trade, as the BCCI officer explained, everything is predicated on documents. You don't have people physically following bags of coffee from Central America through the Central American ports to the United States. So as the bags of coffee are loaded into the containers and the customs officials in the origin countries check on them and the customs officials in the entry countries check on them, they rely on documents because it's impossible to search an entire container ship with 500 or 1,000 of these containers almost the size of this room. The way Bill Basie was able to smuggle thousands and thousands of bags of coffee into the United States with BCCI's assistance is controlling the manifests which accompanied the shipment of these containers from Central America to the United States. In short, Bilbezi's contact in the origin country would prepare a phony manifest listing the containers which were full of Bilbezi's coffee as either empty or short-shipped. When the containers were unloaded in the American port of New Orleans, Miami, or Tampa, Bilbezi's contact on the American side had the manifest, which was contained in a sealed envelope on board, took it out of the envelope, ripped up the true manifest, and presented the manifest to customs.
Presented the phony manifest.
Presented the phony manifest. As far as customs was concerned, the containers nearly the size of this room containing Bilbezi's coffee were empty or short-shipped. Short-shipped is a term meaning that the container, the cargo never reached the origin port. So the three men who helped Bilbezi do this for 2 years described to us in sworn statements how almost funny it was when the crane lifted one of these full containers from the cargo ship, which looks very different than an empty container being offloaded, and the customs agent looking at a manifest of 500 or 1,000 containers and deciding which container to look into, like an IRS auditor, would never look into one of these purportedly empty containers. For 3 years, at no point did a customs official ever look into any of these purportedly empty or short-shipped containers.
Do you have any idea how many containers this involved, either short or?
It would have involved several containers on each shipment, and there were approximately 20 or 30 shipments per year.
Senator, in one shipment, they shipped 45 containers.
So there were 20 or 30 shipments a year,
That's correct.
and they ranged from 1 up to 45 containers per shipment?
Per shipment,
And this went on for 3 years?
5 years.
5 years, and they never had a single container checked?
Not only did they never have a single container checked, they were prepared in the event that a customs agent said, gee, that one looks kind of heavy, let me kind of take a look at that. Of course, it would open and there would have been several hundred bags of coffee. In that instance, Bilbezi's contact at the origin port sent a dummy telex to the contact in the destination port in the United States saying, urgent, this container full of coffee was destined for Honduras. It wound up on the ship by mistake. Please send it back. At no point did Bilbezi's people ever have to produce that telex because none of these containers were ever checked.
Do you have a feel for how many, what the total dollar amount of the smuggling was over those 5 years?
We know
Records
that
available.
over $110 million in letters of credit were initially issued. Because most of the records have been withheld or we contend destroyed, we don't know the amount. We do know that Bilbezi paid approximately $35 million in Central America at the illegal non-quota price for the coffee he brought in. The amount of profit that he made off that coffee is unknown.
Would you yield just for question? I take it any of these containers could just as easily have had drugs in them.
Well,
Or weapons.
the containers are almost the size of this room, and it's common knowledge that coffee is used to fool drug sniffer dogs. So they could have contained anything.
And if none of them were ever inspected, I guess it sort of underscores why we have a drug problem. But I'll leave that for now.
But if you would complete the story here.
Sure.
The coffee is now in the country.
Right.
It's then sold to roasters.
That is correct. Roasters or brokers in New
Okay.
York.
Now, would they have any reason to ask about the origin of the coffee or question the lack of a certificate of origin?
The roasters of the coffee, do you want to?
Senator, once the coffee comes into the United States, and these coffees came in with unmarked bags that were taken to a warehouse in Miami, the bags were replaced. They were marked with numbers to show that the coffee was a quota coffee, phony numbers. Once it is in the warehouse, a certified warehouse, the purchasers, that is the roasters or the brokers in New York or Chicago, do not care where that coffee came from. They do not ask those questions.
Well, a question, technical question, but a few years ago when I used to work for a living, I was involved in meat sales. I know the way meat came in is the normal practice for meat was that title transferred FOB the dock. Now, not always. Obviously, it could be delivered FOB the customer's doorway or warehouse or whatever. But normal practice for meat at that time was that title would transfer on delivery at the dock, that the customer would then have the risk associated with the ownership of that occasionally at the dock, and that the customer would arrange, at least at times, to pick it up at the dock. You're telling me this went to a warehouse and then was picked up at the warehouse?
It was shipped from the warehouse to wherever the final destination was.
Rather than being a direct pickup at the dock?
Rather than be picked up at the dock, because what the Bilbao operation in this case went from the Central American countries directly to the warehouse in Miami. They needed to get it to the warehouse in order to put quota numbers on those bags, to be undetected until it was unloaded and refixed at the warehouse.
And then, Senator Brown, with respect to some of the coffee that went to Chock full of Nuts, as I stated in my opening statement, the president of Chock full of Nuts was actually bribed, giving kickbacks by Munther Bilbesi, straight out of the books and records of Coffee Inc., in order to facilitate with the active participation of a knowing buyer. The chief executive officer, prohibited by the SEC from accepting gratuities, was taking money from Munther Bilbesi's company, which in the books and records of Coffee Inc. was referred to as commissions paid to Arthur Berman, the then president of Chock full of Nuts. So there's no question that at least Chock full of Nuts, through its president, knew that this coffee was being smuggled for a long period of time.
With BCCI, if they were financing these shipments, normal practice would be for them to at least have a certificate of origin, wouldn't it? Included in their papers, and a manifest?
Senator, there's
or
a
a
whole...
bill of lading?
That is correct. Normal practice, yes, that would require a certificate of origin. It would require a letter of credit in which they would show the certificate of origin, a phytosanitary certificate, and the ordinary documents that are needed for this import. As you can see in all of the BCCI letters of credit that were set up to purchase this coffee in Central America,
Senator Brown.
Once it was shipped, in order to bring it smuggled into the United States, they had to amend the letters of credit, and BCCI supplied them with that service.
Is there any way a normal bank would not know that there wasn't a certificate of origin or a proper bill of lading or a proper manifest? Aren't those all parts of the package, the paper package you put together to finance one of these?
Yes, the short answer is yes.
So BCCI, if I understand what you're saying is, BCCI had to be an active participant in the conspiracy to smuggle coffee.
That is correct.
Senator, on July the 10th in Los Angeles, in the RICO action, we took a series of depositions that were videotaped. And one of the bank employees, who was the assistant for the letter of credit gentleman, Mr. Rafi Ahmed, was given the files, as perhaps a former prosecutor would. We gave him the letter of credit files because he had never been produced when he was moved from Miami to Los Angeles. And we said to this individual, who was charged with the LC opening and closing of the files, the question that you just asked, Mr. Ahmed, take a look at these files. Is there anything irregular about them? Yes. What is it? There's no certificates of origin. Every one of these files are cooked. There are pieces missing. What does that mean to you, as you just asked to us? What does that mean to you as a person who worked in the LC department of the Bank of Credit and Commerce? It means to me that the coffee was smuggled.
Let's back up. LC department?
Letter of Credit Department.
Okay.
In other words, the bank's own employee answered affirmatively the question you've just asked Mr. Learman on July the 10th when he was confronted with the very files that his superiors worked from.
Earlier, you all mentioned, I think the words was, there were two prices when we had a coffee quota agreement in effect. An agreement coffee price level and a non-agreement coffee price level. Now, I appreciate sometimes it's difficult to compare qualities and so on, but can you give me, do you have any feel for the difference in price between agreement quota price and non-quota price?
Vincent, answer the question.
In one letter of credit, Bill Basie happened to buy quota coffee along with non-quota coffee. This was in 1984. In this particular shipment for the same grade coffee, quota coffee was $1.40 a pound, non-quota coffee was 40 cents a pound. So at that particular time, the non-quota price would have been roughly 30% or less of the quota price. However, the relationship between the two fluctuated. Generally speaking, the non-quota price was half the price of quota coffee.
Well, if the figure of $110 million over this period of time is correct, and I think you've indicated that that's probably low for the total amount that would have been involved here.
That's what we know about.
We're looking at more than a $50 million smuggling profit.
Actually, that would understate
Of at
the
least
figure.
$50 million in smuggling profit.
Right.
Of which there's only one criminal indictment against Munther Bill Basie for unpaid federal income tax facilitated by the bank in his Florida Corporation Coffee Inc. and he individually for $3.5 million. In other words, it could be argued, although the government indicted him for $3.5 million, they could have indicted him for a substantially larger amount for the one taxable year, for just one taxable year.
Is it your, let's put it on the table. Is there any way, in your view, that the U.S. Customs Service could have not been involved
Senator,
in this conspiracy?
We have documents that are shocking, that show that U.S. Customs knew in June of 1983. Now, they're part of the record. I could hand them to you that show on June 15th, 1983. I have the document here. And I'll
Knew
have it.
that
Coffee
coffee was being
Absolutely.
Coffee was being smuggled into the
And
country.
they knew that Munther Bill Basie was doing it, and they knew it was being done with Mr. Otaño and Valabla on June 15th, 1983. And there's a subsequent memorandum that discusses the method of coffee smuggling, and it was signed by Agent Gonzalez, F. Gonzalez, Senior Special Agent. And the anger of my client is that since they knew it in 1983 and they did nothing about it, if U.S. Customs had indicted them, Lloyd's would not be in the position of doing, in a way, what the United States government should have been doing. We would have never had a coffee loss because he would have been indicted. And that leads to the question, Senator, when you see the other records that indicate from U.S. Customs computers currency transaction violations as of April of 1987, where Munther Bill Basie was cashing at least $50,000 at a time at BCCI's office in Miami and Boca Raton without completing the currency transaction forms. And Customs had in its computers knowledge of this violation since 1983, and that the bank and Bill Basie were continuing to do it. Why was there no indictment for 4 years? The one piece of information it can be argued is that someone in the Justice Department determined that since Bill Basie and the bank and General Noriega had a direct relationship in coffee smuggling, that indicting Bill Basie and the bank would have uncovered earlier the relationship of coffee smuggling with General Noriega. And it can be argued that someone did not want to indict General Noriega earlier, because indicting Bill Basie and the bank would have uncovered the relationship between the bank and General Noriega.
Let me summarize quickly, and maybe you'd correct me.
I'm just
Excuse me, go ahead.
The documents that Mr. Doherty's referring to are Exhibits 4 and 5 in packet number 6.
There's clear proof here that coffee was smuggled out of a variety of countries, that more than $110 million, at least $110 million of coffee was smuggled, that the profits off of that were at least $50 million or more, that the U.S. Customs Service was aware of the smuggling and did nothing to stop it, that the U.S. Customs Service was aware of the currency transactions violations, it did not react, and to this date, there hasn't been a single Customs Service agent indicted in this area?
Yes, and you have to also understand that with our cost, that every time that we would bring this information to Customs in Miami and subsequently to New Orleans, and at the expense of underwriters fly these mounds of records that we've brought here pursuant to the subpoena, and then have to tell U.S. Customs agents this 4-year story in 3 hours or a day or 2 days, Customs in New Orleans would say, that's Customs in Miami's responsibility. Customs in Miami would give us no response, and the next thing that happens is the statute of limitations is gone. And
in addition, you notified the U.S. attorneys' offices and they took no action?
If you have it right here, and someone in London, and then I have to answer the questions that I'm answering to you two in the underwriter's office on Lime Street. Mr. Doherty, can you explain this to me? With the numbers involved, can you explain, with all of the information that's been brought to the attention of U.S. Customs, and recognizing that we have for 300 years insured most of the world's cargoes, why there is no interest in the United States Customs to enforce its own customs laws? No, sir, I cannot. Can you tell me why United States Customs never informed the poor republics of Central America, who are attempting lawfully to grow coffee as opposed to heroin, cocaine, and marijuana, so that they could enforce those laws? No, sir, I can't. Can you explain to me, when the bank participates with a coffee smuggler and an arms dealer, why there's absolutely no interest in the Justice Department to prosecute the bank? You're recommending a RICO case, Mr. Doherty? Yes, I am. Has the United States Justice Department showed any interest? No. Well, if the United States Justice Department has showed no interest, and we've paid several millions of dollars, how much more is this going to cost? With what results?
Now, they would probably argue to you today, well, we just indicted him.
The day before the statute ran.
For tax fraud, not for the arms deals, not for the coffee smuggling.
And then Mr. Bill Basie's lawyers get up in front of a federal judge, one of whom has not had a hearing in 3 years because he's been processing daily criminal cocaine cases, some of which have resulted from the bank's activities, and they're overwhelmed with criminal cocaine cases in the Southern District of Florida. And some lawyer, the 7th or 8th lawyer for Mr. Bill Basie, will get up and say, Judge, it's an issue of fact, because you've never established that all of these instances were coffee smuggling. And the best instance of that is the United States government didn't see fit to indict him.
Mr. Chairman, will we have the Customs Service review this and back up here to explain the
Maybe
apparent,
Mr. Rosenblatt,
malfeasance?
maybe Mr. Rosenblatt and Special Agent F. Gonzalez can explain to your satisfaction why, when they knew it, they never indicted him.
Well, I think it's appropriate for us to pursue that. I think, Senator, you and I ought to sit and think about the sort of the order of that inquiry, but obviously that's an inquiry that ought to be made, and we will. Could I just ask, I didn't mean to...
I had one last question I'd like to cover, if I may. We're trying to put together a puzzle here that seems to have lots of links to it. In your review of this situation, did you run across any links in this smuggling operation? Any links to the First American Bank, to the National Bank of Georgia, or to the law firm, Clark Clifford's law firm?
No, but I'd like to amplify that. The firm of Holland & Knight, one of the finest firms in the state of Florida, was in the same building as BCCI Miami. I don't know whether they had 3 or 4 floors, and BCCI had 5 floors. The floors of the bank and Holland & Knight were stacked on top of each other. During the interrogation that I conducted in California of the bank's officers, including the chief trader whose deposition has been taken, Mr. Rizvi, he was the responsible officer who invested all of the daily money of the bank, Senator Brown, in Abu Dhabi, and then he went to Panama, and he was with, as Senator Kerry would appreciate, Amjad Awan and Belgrami.
I appreciate anybody who can even pronounce the name.
Well, you have 5 people from Pakistan who are working with the bank, and all of a sudden they're sent to Panama, and they work there for, they're the only Pakistanis in Panama, and they worked there for 4 years, and the question is, did you know that money laundering was going on? Oh, no. Did you receive any courses in violations of United States law? No. Who were your lawyers? And he identifies your lawyers, his lawyers. Was General Noriega one of your clients? No. Then what did you do? Well, then I went to Miami. And was there a law firm in the building? Yes. And then you bought 36 branches of BCCI, of an existing Colombian bank, and you never knew from the gross sudden profits of activity in Colombia that there was money laundering? No. Did you attend a single seminar? No. And the question is, did you have the advice of attorneys throughout the United States? Yes. So the question for you is, Senator, that we haven't got, and you have greater resources than we, is to subpoena the files of the law firms that represented the bank and determine in the minutely detailed multi-million-dollar fees how much each law firm charged the bank and on what dates for compliance with the United States Code. That would be a very significant question, and whether or not that law firm that you've identified ever undertook to do it or directed other law firms to do it.
Well, next week we're going to have an opportunity to ask some of those questions of both people in the bank as well as some of the lawyers.
I think, Senator Kerry, one of the problems that we've had has been the blocking of our investigation as your committee with records that have not been produced or represented to be produced, so that we could integrate this a lot sooner.
Well, there's no question that throughout this effort, you know, a lot of people have, I'm amazed at this sort of Monday morning quarterbacking, but, you know, I've got 2 guys on the staff here who've spent most of the last couple of years trying to get some of those records, and we understand the stonewalling, but it's very, very hard, and there has indeed been sort of an institutional stonewalling, because you're running into it with the liquidators, you run into it with the court, you run into it with the bank, with a lot of law firms. And one of the great difficulties is that obviously a law firm can say to you, oh yes, you know, we're going to cooperate, we'll give them, and they sort of ante up a few documents, and you're sitting there, and unless you have an insider or somebody who's specifically telling you what document you're looking for or where it is, you don't know till you get further down the document trail that there may be more documents, or that it hasn't been fully forthcoming, or that they've been shifted cleverly and quickly from BCCI Miami branch to London or to Amman or somewhere. And I am convinced at this moment that there are an awful lot of documents out there that tell an extraordinary story that are sitting in foreign countries as a consequence of the delay here in seizing and in moving and in investigating. And you're paying some of the price of it, we're paying some of the price of it. It's very difficult to get all of those.
Senator, can I make 2 points with you? You, on opening statement, referred to the issue of Iraq. And and arms transactions. I did wish you and Senator Brown to know that in the most recent discovery response from Mr. Bill Basie, we have records that will be placed in the evidence with your permission to show that Mr. Bill Basie attempted to sell parts for F-14 jets, American-made Grumman F-14 jets to Iran. That there are records that show that Mr. Bill Basie in Hollywood, Florida, during the Iran-Iraq year, Senator Brown was receiving inquiries from the First Minister of Iraq to attempt to buy American-made Red-Eye, Sidewinders, other surface-to-air missiles, tanks. We even knew when we were investigating early the telex traffic to show the coffee shipments. We came across a telex that showed an incoming telex to Mr. Bill Basie's office in Boca Raton from South Africa offering to sell enriched uranium to a Middle East country.
Any indication as to which country?
In the context of the incoming telexes, it would have to be argued that it was either Iraq or Iran. That information was given to 2 FBI agents who looked at it before our involvement and confrontation with Iraq 2 years ago, and there didn't really seem to be any interest to take the totality of all of the pieces of a man who claims to be a coffee merchant, retired, who is receiving incoming telex traffic for each coffee transaction in Central America, any interest in 20-millimeter cannons, armored personnel carriers, tanks, none. With a man who did have a former CIA agent working for him in the coffee business, and at different times a retired 3-star Army general traveling with a coffee smuggler to Honduras, El Salvador, and Guatemala during the times of the what is called and referred to as the Iran-Contra affair. Again, no interest.
You don't mean U.S.?
I mean that a lieutenant general of the United States Army, and you may not have been here, James Vaught, a distinguished United States flag officer who organized the ill-fated Iran extraction of the hostages from our embassy when the helicopters crashed in the desert. That was his plan. That man, upon his retirement from the United States Army, who went from a NCO to a 3-star Army general from South Carolina, suddenly appears at Mr. Bill Basie's residence and attempts to go into Central America and sell Turkish or South Korean-made weapons with Mr. Bill Basie's employees in Honduras, Guatemala, and El Salvador. We have a sworn statement here. The following year, Mr. Bill Basie attempts to sell or listens to Adolfo Calero's shopping list of Soviet-made weapons. Now, the question is, when this information is brought to the Justice Department and there's absolutely zero interest with a man who flagrantly violates the United States Code, who United States Customs knows is violating sections of the United States Code, why? And we even have now received a copy of a passport of the government of El Salvador which shows Mr. Bill Basie as a Salvadoranian that was issued by the government of El Salvador's embassy in Geneva, arising out of his activities in selling weapons to El Salvador. Now, what is a Jordanian in a false name using a Salvadoranian passport today? How did that happen? How could that all happen without the United States Immigration Department, the United States Customs, the United States Justice Department, the United States Central Intelligence Agency, the National Security Council, all being unaware? It does just not happen that a distinguished United States Army officer attempts to broker weapons.
Do you have any idea how do you know that a CIA man or former CIA person went to work for Bill Basie?
His name is William Toten, T-O-T-E-N. He lives in Alexandria, Virginia. He was subpoenaed to give testimony a year ago. I conferred with his attorney. We'll introduce the copy of the subpoena and the name of the attorney. And his attorney admitted that he worked for the agency and stated, to save a lot of time, that he would not permit me to ask any questions concerning the length of his employment, what he did with the Central Intelligence Agency, or what he did with Mr. Bill Basie selling coffee shrimp. And Senator Brown, There
Is
is
there-
in a record that we received last week, a very simple document called decoding, and it's a vertical line that lists commodities like coffee and shrimp, and you correlate it to weapons. Now, what is a coffee merchant from Jordan doing with a sheet that codes commodities for weapons? It, as I've said to many people, involves like taking 3 gigantic
Don't-
crossword puzzles that have pieces missing, and they're all thrown in a big bin, and you shake it up and throw it out on the floor, and then someone has to sort out the puzzle of BCCI, the puzzle of Munther Bill Basie, and his other activities.
Well, don't all good arms merchants need a nice cover enterprise?
They do. They certainly do. And
His happened to be coffee, no?
that's what he says. That's what the man says. And
Let me ask you something, because I don't want this Mr. Toten, it's the first time I've heard his name, incidentally, I don't want him swept into a rug of sort of a sense of something going on here. I mean, is there any allegation that somehow he's done anything wrong, or that...
we haven't taken his testimony. All of the telex traffic shows that William Toten, a former agent of the CIA, according to his attorney, was selling blackened shrimp, castrated sheep, and coffee beans.
And this, the telex traffic that you have uncovered in the course of all the document demands that you've made, is that correct?
That's correct.
Okay. But again, there is no allegation at this point of anything but questions about what he was doing.
Yes, and we also know on that point, Senator, that that same individual participated and received a fee, a $50,000 fee, for his services in concluding Mr. Bill Basie's litigation for a tank commission. He was paid $50,000, and there's a copy of that check. So what is an ex-CIA agent who then becomes a commodity broker receiving a fee to conclude a $700,000 settlement?
Just a couple of quick questions to wrap up here before we finish. BCCI used cashier's checks to enable Bill Basie to take his smuggling profits without paying U.S. taxes. Is that accurate?
Yes, our records would indicate that between 1983 and 1987, I think the actual quantum of them was around $11 million.
Now, was there any reason that BCCI should have known what it was issuing cashier's checks for, that it was in fact part of that? Because it's not unusual for a bank to issue a cashier's check.
The answer to that question is yes. When the
Which,
bank...
yes, it's not unusual,
Yes.
or yes?
Yes, they should have known it was unusual. When the bank employees were interrogated by us, did you have any problems with writing out on March 3rd, 1986, 86 cashier's checks to Louis Altamar for $25,000? Yes. I mean, didn't the thought ever occur to you that you take $25,000, multiply it times 86, and make out one cashier's check? Yes. Why didn't you do that? Well, that's the way Mr. Bill Basie wanted it. Why? So that he could take those checks, according to Louis Altamar, not the bank employee. He could take those checks and buy smuggled coffee without using letters of credit.
But if a client comes into a bank and says, I want 80 checks in this amount, is there an automatic reason that a teller or somebody's going to make a judgment about what they want them for?
There are requirements of the United States Code that those transactions be recorded, which were not by BCCI.
That's what I'm getting at.
Number two, there is a requirement of the United States Code that any individual who takes more than a certain amount of cash or currency or cashier's checks out of the United States commits a crime. When the bank has reason to know, actual knowledge, that the person, the payee of the check, the employee of Bill Basie, is going to fly to Honduras or Guatemala with $3 million worth of cashier's checks, they know what's going to happen. And when that employee tells them, when he brings some of those checks back for refund, where he's gone and what he's done, the bank is more than on actual knowledge of a criminal conspiracy.
And in your effort to try to get discovery to find out what had happened with respect to these checks, did you have trouble with the bank in getting them to produce the canceled checks?
The court file is from me to you on that issue alone. The people that drew the checks are now in Turkey.
And that is because if you were to have seen the endorsed side, not just the face side, but if you saw the endorsed side, then the fraud would have been self-evident.
Yes, sir. If we had received in 1987 all of the cashier's checks in their original form and the endorsements, we could have completed the investigation. And moved for summary judgment at that time.
Now, I also just want to clarify for the record, because I don't want any unfair insinuations cast here. You've raised a question about General Vaught's participation, but so far as you know or anyone knows, there's nothing that indicates, again, any illegal activity on the part of General Vaught.
That is correct.
It's perfectly possible that he could simply, I mean, this is where he wound up. He was employed because he had a good business opportunity, but he didn't. There's no showing that he was aware of anything.
Absolutely not.
I just want the record to be very clear.
Absolutely not. We've brought a sworn statement, and the General's testimony was that no arms transaction was completed and that he disassociated himself with Mr. Bill Basie, Senator Kerry, when it became apparent to him that Central American officers were demanding kickbacks. And General Vaught's testimony was clear.
Who were the two generals who got paid money in Guatemala?
We believe...
It was General Alejandro Gramajo, the ex-Minister of Defense, and General Mata, who was at the time the head
General
of
Mata?
Yes.
He was
Chief of
previously,
Staff.
he was Colonel Mata, wasn't he?
Correct.
He's now General?
Yes. He's retired now.
Let me go into one last inquiry. Now, up until now, everything that you have set forth here has been documented by the discovery process, by the confessions themselves of participants in this smuggling scheme.
That is correct.
By bank checks, by canceled bank checks, by memoranda, so that all of your testimony to date before this committee is in fact testimony based on evidence that is admissible in court and that you have learned on a first-hand basis. Is that accurate?
That is accurate.
Not only admissible in court, Senator, it's all been filed with the court. So if we wish to conceal what we've told you today, we couldn't do it.
Correct. And all of it obviously subject to pains and penalties of perjury. Let me just ask you one thing that is not based on documents. But it's an area that has concerned me in the course of this investigation, and you said something to me literally 5 minutes before we came in here that is curious, and I want to just acknowledge right up front, it is your speculation, it is not factual. But there are rumors around, there's a lot of street talk around about payoffs and about who's benefited in this process. And one of those allegations regards sort of lists or names of individuals in this country who have received sums of money, either through BCCI directly or otherwise. Now, do you have any knowledge of that, or do you have any sense as to whether any of the players in this scheme that you've laid forth here might be able to shed light on those payments?
I have both direct and indirect knowledge.
Okay. Would you share the direct knowledge with us first?
The direct knowledge is even the most recent article published by Harper's Magazine of this month that makes this by the author. The statement of fact that the Federal Reserve possesses a source document that would identify all of the individuals, politicians, other people who possess power and influence, who have received substantial sums of money from the bank, both in the United States.
Okay, but that's not direct knowledge. That's, again, that's indirect knowledge. I mean, you've read in a magazine somebody is asserting this.
Number two,
the record ought to show also that the Fed has denied that that list exists in testimony before this committee.
Okay. I am also told, by way of hearsay, that when the Price Waterhouse reports were prepared in the months prior to the action taken by the Bank of England, that there is a Price Waterhouse report itself that identifies the individuals both within the world and therefore within the United States, who have received large political payoffs.
Now, is there a possibility that some people might not have been indicted because they could name some of those people?
Yes, that's the next thing that's my inference. And I would say this.
Now, this is purely your speculation.
I wouldn't state this purely as my opinion. That if you look at the activities of Bill Basie as one case, we know that an individual in Boca Raton and a specific bank officer whose name is Malik at a branch office in Switzerland, Swiss Cottage in London, England, set up phony accounts for 3 ex-Bill Basie employees. They're attached to the affidavits of the 3 men that work for him. Those false names were Frangiuli, Labaro, and Chevre. And over several millions of dollars were transferred from the United States by BCCI people in Boca Raton, personnel, Boca Raton and Miami, to BCCI London to facilitate 2 functions of this bank, which were first to enable individuals to make money in a criminal enterprise, in this case, coffee smuggling. Second, to take that capital and evade United States income tax laws. Third, to allow the interest from that capital to similarly evade United States income tax laws. An example was what was done with the Bill Basie threesome.
Let me try to stay on track here. Okay, so you've got...
I'm getting to it, Senator.
What you have is the continuing criminal conspiracy as to this fraud.
Yes.
Where does that lead you?
All right. Since that was done in this case, and the common bankers were involved, as I know, in other similar tax evasion schemes, the question is why what is referred to as Main Justice, Mr. Mueller, and the tax division have not indicted the bank officers.
Which bank officers?
The bank officers of BCCI. Why they have not indicted them for violations of United States law. And the answer to that would be...
Which bank officers where?
Here. Why no criminal indictments
Here where?
in the United States of America?
All through the United States.
The Southern District of Florida.
All the bank officers.
Why have the bank officers who participated in income tax violations in the Southern District of Florida not been indicted? And an answer, a possible, plausible answer is, if those individuals are indicted and extradited to the United States, they would be in a position to bargain for their reduced sentence to name names of other individuals who did use political influence,
okay,
or at the least to name the individuals who participated in other income tax violations.
Okay, let me ask a question now. There was an indictment recently, correct?
There was
an indictment in Tampa.
There was.
And that indictment was not of the kinds of officers or the level of officers then that you're referring to.
Exactly.
Is it possible that they don't have a case against those officers, that they can't indict them?
No. They can make a case. And the documents that we've shown you, if they indicted Bill Basie and they indicted his accountant Grushoff, and they have actual knowledge of the names of the individuals who facilitated it, not only for Bill Basie, why weren't those bank officers indicted at the same time?
Well, it's a question we'll ask. I don't have the answer to it. Let me thank you, both of you, for all 3 of you, for your testimony today. I think it's been very helpful in laying out, as we said we would at the beginning, one particular sort of opening or window, if you will, on how BCCI functioned. Obviously, there's a lot more to tell. You've scratched the surface of the questions about a number of branches in Medellin. Pretty hard to buy branches of a bank in Medellin, Colombia, without knowing what kind of proceeds are going through those banking accounts. Similarly, the Cayman Islands and other activities of BCCI present their own set of questions. But this is particularly interesting because this is on the shores of the United States. Much of the activity came out of Florida, and because it obviously raises some serious questions about capacity to enforce some of the laws we have on the books and willingness to. I am personally convinced, and I've said this publicly before and I say it again, we've got an awful lot of very dedicated customs people who work awfully hard and who are overworked and who are being asked to do an almost impossible task. And one of the things that I'd like to highlight perhaps through this is the degree to which the entire law enforcement community over the course of the last 10 years has been diminished in its ability to be able to do what we want it to do because it doesn't have the resources. There is a screaming need at the lower end for a lot of people who are risking their lives and going out and doing the impossible on a day-to-day basis to be backed up. And that backup comes from us here, and it comes from down the street at Pennsylvania Avenue and from the agencies. And there clearly are some glaring issues about the degree to which that's occurring and people being left stranded out there and just unable to follow through. Now, I don't know what happened here. As Senator Brown has suggested, it's yet another area of inquiry that we've got to try to find out what happened. But I want to thank you for being here. Lloyd's, as I said at the outset, expended $6 million to pursue and produce the documents that you are sharing with us and the evidence that you have shared with us, and we're very grateful, obviously, that you're able to do that. I think it is very helpful to us, and it is the committee's hope, obviously, that we'll be able to shed more light as we proceed down the road. On next Tuesday, we will be meeting in the Hart auditorium for the hearings. In fact, all next week, I think we're over in Hart. And we will be hearing from a 13-year veteran of BCCI, in fact, a gentleman who was one of the significant players here in the United States within the BCCI banking structure. And that will be Tuesday, and we'll announce the process for the rest of the hearings in the course of next week. So we stand adjourned until Tuesday.
That concludes today's hearing of the Senate Foreign Relations Subcommittee. The subcommittee will continue its investigation of the Bank of Credit and Commerce International next week, with hearings beginning on Tuesday. On Thursday, the subcommittee will hear from Clark Clifford and Robert Altman, two former officials with First American Bank. Investigators have charged that Washington, D.C.-based First American was secretly controlled by BCCI. If you'd like more information on today's hearing, write to the Senate Foreign Relations Subcommittee on Terrorism and Narcotics. The address is 446 Dirksen Office Building in Washington, D.C. The zip code is 20510.
C-SPAN 2 proudly marks its 5th year telecasting live coverage of the U.S. Senate. C-SPAN 2 is part of the C-SPAN networks, privately funded to serve the public by America's cable television companies.